Kim, you can let Miss Jameson in if you see her, right?
Okay, I will.
Okay. All right, so wait, I think we're ready to start. Yeah. Okay, when you're ready, Miss Clifton. I guess we're starting with four. We can do the defaults first.
Oh,
Okay, so we'll do
you
it's
wait, you want me to start with number four, not number two? Let me just ask one question. Mr. Thomas, was Mr. Hauser on 817 West Grand? Yeah,
Yes.
he is. So we don't want to start with that one because
no,
he's
no,
still in the breakout. Okay.
right. So
So you
we're gonna
want
do
what, Judge?
number
Four?
four and then I think it's number eight. Those are no one's here on those.
Number four and number seven.
Okay,
Just
I'm
okay,
sorry.
after just tell me as I go because
Okay,
I have
thank
to
you.
cut and paste. I'm sorry.
Okay,
No,
that's
thank
okay.
you.
I have to cut and paste from your docket. Okay, so calling case number 23008694694CH. This is with regard to 595 South Green, Detroit.
Council appearance.
Good morning or good afternoon, Your Honor. My name is Andrew J. Thomas. I'm an attorney, P67948. I'm appearing on behalf of the plaintiff in this matter, the Detroit Land Bank Authority. Today is the time and date set for a default hearing concerning 595 South Green. The complaint in this matter was filed on October 4th, 2023. A motion for alternative service was filed on October 5th, 2023. The order for alternative service was granted on 10/16/2023. The service, the order of alternate service for first class mail was done on 10/2023. The alternate service posting in three public places was done on 11/17/2023. The order for alternative service posting at the defendant property was accomplished on 11/18/2023. The default request and entry was entered on 2/13/2025. The Detroit Land Bank has not received an answer, nor has one been filed with the court. At this time, the Detroit Land Bank Authority would ask that a default judgment be entered in this matter.
Okay, based on the representations placed on the record, the court is satisfied and the court will enter default judgment as it relates to 595 South Green, Detroit, Michigan 48209. And
Thank
Mr.
you very much,
Thomas
Your
will
Honor.
present that to the court for entry. Thank you. Let's go to number seven.
Number seven.
Yeah.
This is case number 2400445 with regard to 14255 Young.
Council appearance.
Good afternoon, Your Honor. Andrew J. Thomas, P67948, appearing on behalf of the Detroit Land Bank Authority. Today is the time and date set for a default judgment against 14255 Young. The complaint in this matter was filed on 5/23/2024. A motion for alternative service was filed 6/21/2024. The alternative service order was granted on 6/24/2024. The mailing by first class mailing pursuant to the order for alternative service was accomplished on 6/26/2024. The posting in three public places was accomplished on 8/7/2024. The posting on defendant property pursuant to the order of alternative service was accomplished on 8/6/2024. The defendant's default request and entry was entered on 10/3/2025. The Detroit Land Bank Authority has not received an answer to its complaint or a motion to set aside the default as such, and nor has one been filed with the court as such. At this time, the Detroit Land Bank Authority would ask that our motion for default judgment be entered.
Based on the representations placed on the record, the court is satisfied and the court will enter default judgment as it relates to 13645 Castleton, Detroit, Michigan 48227. And we'll look for the order to be presented, Mr. Thomas.
Thank you very much.
Thank you. Um, and I guess, where,
I'm sorry.
Ms. Clifton,
I didn't call Castleton. I called Young.
did I make a misstatement, Mr.?
Oh, yes, that was 14255 Young.
I'm sorry, let me stand corrected on the record. Yeah, because that Castleton is going. I'm sorry, I apologize. So thank you, Ms. Clifton. So the default judgment is as to 14255 Young, Detroit, Michigan 48205. 14255 Young, Detroit, Michigan 48205. Thank you very much.
Great ears, thank you.
Okay, thank you. Yeah, because she writes it down.
Uh-huh. Okay, so are we going to England? Number 8?
Yes.
Okay, this is case number 24016-313CH with regard to 17433 England.
Council appearance for the record.
Good afternoon, Your Honor. Sheila Bellew, P55700, on behalf of the Detroit Land Bank Authority.
Okay, what's your pleasure with regards to this property?
The Land Bank filed its nuisance abatement complaint on November 5th, 2024. The alternative service order was entered on February 5th, 2025. There have been no responsive pleadings filed in this case. Recent photos were taken on October 10th, 2025. The property remains vacant and blighted. On behalf of plaintiff, I'm asking that this court enter this default judgment in favor of plaintiff so the land bank can abate the nuisance.
Based on the representations placed on the record, the court is satisfied, and the court will enter a default judgment as it relates to 17433 England, Detroit, Michigan 48212, and we'll look for the order to be submitted to the court. Thank you.
Thank you.
Okay, and where are we going now?
We're going to Castleton.
This
Okay,
is case number 24018-275CH 13645 Castleton.
council appearance.
Sheila Bellew, P55700, appearing on behalf of the Detroit Land Bank Authority.
And what's your pleasure with regards to this property?
The land bank filed its nuisance abatement complaint on December 16th, 2024. The alternative service order was entered on March 17th, 2025. No responsive pleadings have been filed in this case. Recent photos were taken on November 18th, 2025. The property remains vacant and blighted. On behalf of plaintiff, I'm asking that this court grant this default judgment motion in favor of plaintiff so the land bank can abate the nuisance.
Based on the representations placed on the record, the court is satisfied and the court will enter a default judgment as it relates to 13645 Castleton, Detroit, Michigan 48227.
Thank you.
Thank you.
Are we going to Hazlet? Number 11?
Yes, thank you.
And we have parties present. Okay, this is case number 250030988CH with regards to 6115 Hazlet.
Council appearance for the record.
Good afternoon, Your Honor. Andrew J. Thomas, P67948, appearing on behalf of Detroit Land Bank Authority.
And those parties who are present relative to this property, please state your names.
Good afternoon, Your Honor. Peter Hirakis, property owner.
Yeah, thank you. I see there's
Yeah.
Go ahead.
Yes. Good afternoon, Your Honor. Maria P. Harakis, just a law secretary for Mr. Peter Harakis.
Okay, thank you. Mr. Thomas?
The Detroit Land Bank respectfully requests entry of a default judgment in this case. The defendant is a sophisticated owner. He purchased the property from the Wayne County Treasurer for only $500. He owns several other distressed properties across Detroit. Rather than rehabilitating or maintaining them, he holds them for speculation while the neighborhoods bear the cost. This particular property remains vacant. It's still open to trespass. There's overgrown vegetation, debris, broken boarded windows, loose boards, peeling paint, rotten wood that allows water and animal intrusions. the property's condition endangers children, attracts crime and vermin, and drives down the surrounding property values while driving up the surrounding insurance costs for the neighbors and residents. At the last hearing, Mr. Harakis openly stated that he did not intend on fixing the property at all. His continued inaction and admission of his inattention demonstrates disregard for this process as well as the well-being of Detroit residents. As such, the DLBA urges the entry of a default judgment.
Is there anything you want to add, Mr. Rockets?
Yes, that's not true at all, Your Honor. Counsel has been provided photographs, updated. I have in fact completed the repairs, it is not open to trespass. Photographs have been obtained have been submitted to council, as well as the land bank inspector was there a couple days ago and verified the fact. In fact, it has not been completed yet because of the weather. And I have repeatedly asked council to consent to an adjournment so I can complete it after the repairs, but no answer. Instead, it was just ignored.
When is the last time that we were here, Mr. Harakis?
A month and a half ago, I believe. Since then, dramatic repairs have been completed.
Mr. Thomas, let me.
I'd like to show you
Okay,
I mean, it's
that's
dramatic.
what I was going to ask.
We can all agree on that. Let me see.
Can you
How
share?
do we share? And
Are you able to share, Mr. Thomas?
I'm here we go.
Okay.
So do you see them?
Yeah.
So, and these are his pictures. These are the best angles. This is what he thinks the winners are.
So it's just as it relates
Those pictures are over a month old, Your Honor. The updated pictures have been uploaded, have been submitted to.
You sent these to me, Mr. Harakis. These are your pictures.
Those pictures were a month and a half ago, sir.
All right. So do you see on the side where it says Wednesday, 1/28/2016? These are the ones that you sent me, sir.
Right, and those are pictures of over a month and a half ago. I told you, buddy, they were
Well,
shared from.
Okay, but why would you send him those older pictures, Mr.
They
Harakis?
were shared from my office in error. The updated pictures apparently have been mixed up in my office. I'm currently not in my office to point out the pictures, but even those pictures there show that at the time, right after the hearing, everything was boarded up, painted, paint was omitted. Since then, the entire house is just about finished. The front of it is completed, but I don't have the ability to share these documents, which is what I asked for an adjournment for, so I can show the updated pictures.
And you got the adjournment, sir.
Yes, since then, after this, I did not get the adjournment because the weather has not allowed me. These pictures are over a month and a half old.
So what are you saying? What else has been done since then?
The entire front, all of the windows have been replaced. All of the paint has been scraped off. Obviously, we can't paint it with this kind of weather now. But all the grass has been cut. Everything has been done but occupied. The electricity has been turned on. The water is on. But we can't do much.
But the thing is why would you send Mr. Thomas the wrong? Okay, I'm not going to belabor that.
Your Honor, they were sending from my office in error. These are not the newest pictures. I have the pictures on my phone. I cannot share them, but if I share.
Okay, hold on. Mr. Thomas, do we have 2 weeks out? Let me see. Somebody tell me, when's our next day? Because I'm sure it's the quickest turnaround.
The next Zoom hearing is March 18th. Mr. Harakis is a New York City attorney, so he probably doesn't want to.
I am not an attorney. I am not an attorney. Stop lying to the judge. I
Well,
am
you
not
said
an
you had a
attorney.
law clerk. I figured that
Okay,
meant you wanted
okay,
She's
to-
my
hold on,
secretary.
everybody, please, please. Mr. Thomas, when is our next date?
The next date is February 4th. That's in person, and the next Zoom is February 18th.
February 4th? The
I will not.
18th? No, Mr. Thomas, it came because I'm doing the tax foreclosures on the 18th. Did they give you the 18th?
I believe so.
No, Kim, isn't that tax foreclosure day?
It's blocked as such, but we understood those cases were going away. But
Oh,
they did give them the February 18 date.
okay, so
we gave them that.
they're moving all those?
Nothing right now is scheduled.
Okay. So we gave them 2 o'clock? I hate to have a double book. Okay. I just hate to be, because I'm stressed enough as it is doing these multiple dockets. What was the date after the 18th, Miss Clifton? No,
March
Miss,
4 is in
um,
person.
we need to get this done. Mr. Harakas, somebody's gonna have to be here on the 4th, because
Again, Your Honor, currently I'm in Europe, Your Honor. I'm not going to be able to make it even into the country by the 4th.
somebody's got, because I've given you this opportunity.
Well, Your
The-
Honor, I can submit the pictures to you. I can email you the pictures. I can email the council the updated pictures. You'll see the dramatic changes. I mean, I'm not,
Okay, what you need to do is, I'm gonna put this over to the 4th. You need to get Mr. Thomas the, the, right, you don't have anybody local?
Your Honor,
I
if
have,
I may, I just emailed Attorney Thomas the updated pictures. It was sent in error. I
Okay.
accidentally attached the wrong
Okay,
picture.
well, we'll recall this. Miss Clifton, you can place him back in the waiting room. Mr. Thomas, I don't know, but you need to hold on because we're gonna redo this.
I've received their email.
Okay, but you can look at them and we'll move on. Miss Clifton, put them back in a breakout.
In a breakout or the waiting
I mean,
room?
waiting room, I'm sorry.
Okay. Mhm.
Mr. Thomas, I stopped sharing. You can look at them and then we can have a discussion. Okay, thank you.
Thank you.
Okay, so, okay, what else do you have, Mr. Thomas? Or Miss Bellew, did you have anything else?
Your Honor, I have something else, but it's not on our docket because it wasn't my motion. It was a motion regarding 18031 Sunset, and it was
Okay.
filed by the persons present.
But you didn't have it though. I'm not gonna,
I filed a reply.
oh, you
The
did?
person's in the waiting room.
Okay, but you said you didn't have their motion? I'm sorry, maybe I misunderstood what you said.
I did eventually I got a copy of it. I got
Okay.
when that the hearing was going to be scheduled. I think it was in December, so this was adjourned. So I'm aware of it. I wasn't served or anything, but I did file a reply.
Okay. This is Sunset?
This is Sunset.
And the owner is Mr. Raston, Anil Raston.
Okay, but so you're prepared to go forward, Miss Bellew?
I am.
Okay, Miss Clifton, you can let that person
Mhm.
in.
Joining. Judge, are you able to make Miss Jameson and Miss Anderson co-hosts, please?
Yes, okay.
Mr. Raston, are you here? Can you unmute, start your camera, please? Okay, there it is. This is case number 23003429CH, DLBA versus Anil Raston.
Yes.
Council appearance?
Our Sheila Bellew, appearing on behalf of the Land Bank, Your Honor, P55700.
And sir, would you state your name? Mr. 18031 Sunset, sir, would you please state your name? Sir,
Yeah,
can
my name is Anil Razdan.
okay, thank you. Ms. Bell, you said this is his motion to set
Yes, this
aside
is,
the default?
yes,
Correct.
this is his motion.
It was to set aside the default judgment. Sir, you can make a statement.
Yeah, I purchased this property and it was not rehabbed at that time. So I rehabbed it and put it on rent. But the tenants trashed the property and then I put it on rehab again. And I paid $25,000 to the person to rehab. And I have put in a quotation there. And then whilst it was being rehabbed, the land bank took it over. And I had no idea. I got no notices from the land bank anywhere. I mean, I continued to pay the taxes, and the tax people, they know my email address, they know my physical address where I am located in Australia, and they did not notify me at all, and my property was taken over by them. And I lost now that 25,000 that I paid to the contractor. He's not willing to honor that anymore. He's saying the prices have changed, that 25,000 is gone, and a fresh rehab proposal is required. And she can't even go inside because the land bank is not allowing her to go inside. So she doesn't know what the actual cost now will be.
Ms. Bellew?
Good afternoon, Your Honor. Just as background, the land bank filed its nuisance complaint in March 16, 2023, and Judge Frizard entered a default judgment on February 15, 2024. That judgment was recorded on January 6, 2025. No one appeared at that motion. And so since as far back as March 20th, 2025, the land bank has been willing to set aside this default judgment outside of court, but Mr. Razdan has rejected the land bank's offer because he's unwilling to pay costs in the amount of $665. So the relief that I'm seeking today on behalf of the land bank is I want to ask the court to strike his pleadings because Mr. Razdan is not an attorney. And so by drafting this motion and appearing on behalf of, on behalf of the motion for the property owner, Anil Razdan Self-Managed Super Fund. So he is not the owner of the property as an individual. So he's appearing in court on behalf of a separate entity. And that shakes out to be the unauthorized practice of law.
Because he's supposed to have an attorney representing him,
Absolutely.
right?
So he filed these pleadings as like pro se, as if he's the owner of the property, but he isn't.
So, Mr. Razvan, I don't know what's going on, but it seems like it appears that they attempted to resolve this with the entity by just asking to pay the cost. I mean, if you're not willing to pay the cost, I can't set this aside. And additionally, you have to have an attorney because of the fact that this is a legal entity and it's not you in your individual capacity. So at this point,
This fund is actually owned by me. I am the owner of this fund, and I invest
okay, but
this.
yes, I understand that perfectly, but because it's a
Yes.
fund, you have to have legal counsel representing you. And I can't, that's the bottom line. So at this point in time, I'm not in a position to set it aside in any way, shape, or form because it's not properly before me. You need to get legal counsel. You cannot do this in your individual capacity because this is an entity. So at this point in time, I can't, and you need to get legal counsel. And as Ms. Bellew had indicated, they were trying to work with the entity, and all they asked was that you pay the $665. If you're not willing to pay that, there's no way that the court is going to set this aside anyway. I can just tell you that. So one or two things needs to happen. The entity needs to pay the $665 that they've asked, or you need to get legal counsel to represent you because you cannot represent yourself in the individual capacity. So at this point in time, the court is going to deny the relief requested, but I've given you your options and you need to pursue those. Ms. Bellew?
Your Honor, yes.
Okay.
And so I just want to say for the record that the land bank is still willing to work with Mr. Razdan as trustee of the Superfund. But at this point, we want him to enter into a set-aside agreement with cost in the amount of $665 and abatement terms because, as he said, the property still needs to be rehabbed.
Right. So the thing is one or two things, Mr. Razdan. One, you have to enter into agreement, or you're going to have to get an attorney to come forth and represent you because you cannot represent this entity.
Okay, all right.
Okay, thank you very
Okay,
much.
thank you.
You're welcome.
Thank you, Your Honor.
Thank you.
Thank you.
Okay, so that's denied, Ms. Clifton.
Thank you.
Okay, so are we, I think, are we done for you two?
No,
What
unfortunately
number?
not. We have
Number two?
the Hiriakis matter still with the new picture. And then I
Oh,
have
number
yeah,
two.
number 2.
Okay, okay. Miss Clifton, can you bring back in those individuals on here?
Okay.
That's the Hazelton, right? Yes. Okay, we're back on the record with regards to 6115 Hazlet. Mr.
Okay.
Tom-
So the property does look better. And the land bank, which we've already extended to Mr. Hiriakis, at this point, seeing the progress that's been made, would be willing to enter into a rehab agreement. But Mr. Hiriakis has said he has no interest in signing a rehab agreement.
Mr. Hirakis, that's your option. You have to work within the confines of the law. Either the
Uh,
court is going, let me finish, sir. Either the court is going forward with the default, or you can enter. Those are your only two options, sir.
Okay,
That's
well,
it.
the rehab agreement has to give me enough opportunity to complete the work. Look at what's going on in the weather. You see on the photographs, we have over a foot and a half of snow.
Right,
I
right.
can't,
But you need to, like I said, if that's your option, you can discuss that with Mr. Whoever Mr. Thomas puts you in place with in
okay,
to have that discussion. So, Mr. Thomas, do we want to adjourn this, or what are we going to do?
Let's adjourn until that next Zoom hearing. And the terms are the same as we've offered them before. It's 6 months. The snow is going to be gone in 3 months, or and
okay.
you've already made very nice progress. So if
Well, I want to bring your attention to the house next door, which is owned by Land Bank, and it's wide open. Trespass
Okay,
with children
Mr.
is
Hirakis,
being
that's not in
suggested.
front of me. That's for another day. I have to deal with the cases that are in front of me.
No,
Your ca-
but it is, Your Honor, because that is what prohibits me, what prohibits me from finding tenants in these properties. When I am surrounded by nothing but decay, which is owned by Land Bank, who is trying to get yet another property from a taxpayer, um, it limits my ability to find prospective tenants or buyers.
Okay, but Mr. Hirakis, you purchased this property, so you purchased the property. I don't know what the condition of the next door property was when you purchased it, and that's what you're gonna have to contend with at this juncture. The only property that's in front of me is your
Mhm.
property. So if you want to talk
Okay.
to the land bank, I don't know if it's even an option to purchase that property next door. That's on you, Mr. I think Mr. Thomas told me that you purchased this one property for $500 for the land bank. And if you're an out-of-town investor, then you have to deal with what's going on in the city of Detroit. And that's
Uh,
up to you.
okay.
Okay, thank you very much. So we'll adjourn this to Mr. Thomas again. The date is?
Um, Mr. Rockis, how does February 18th sound to you? Zoom.
Actually, February 18th is the day that I'll be traveling. So if I could get the next available date after February 18th. Give us a
March
little bit more
18th.
time. Give us a little
March,
bit more time. Give us a
March
little bit more
18th.
time to do more of the painting. February 18th, we're not going to be able to paint
March,
anything.
March 18th, and then we'll see where we are because as Mr. Thomas indicated, you basically get 6 months anyway. But we'll put this out to March 18th. March
Okay,
18th via Zoom.
okay,
Okay, thank you very
Thank you
much.
very much, folks.
Okay,
thank you.
Mr. Thomas, does that conclude our cases for nuisance?
Unfortunately not.
Oh my
We still
God.
have number 2 there, Grand Boulevard.
Okay, all right. Is someone present for that?
there's an attorney and the client. If
Okay.
we've got a giant docket, maybe I'll offer them an
Yeah,
adjournment
you want
until
to, okay,
the
let's do
18th.
that. Because actually I haven't had lunch, and while you're dealing with getting everybody together for the
Quiet time.
quiet
QT.
title, I'll be able to hopefully put something in my mouth.
All right.
Okay. Mr., you want to bring them in, Ms. Clifton and Mr. Thomas, and I'll pause the recording.
They are in a breakout,
Oh,
so,
Mr. Thomas Ms. Clifton will send you an invitation to that breakout.
well, he just needs to rejoin. Were you in there? Yeah, I'll send an invite. Okay.
Okay, all right.
Thank you.
And
And
then
then we'll
I'll,
start
we'll let
checking in.
everybody get themselves together for
Mr. Thomas, can you stop sharing? I can't, I need my screen back.
I don't know where that button is
Oh,
anymore.
wait a minute.
wait, let me see, share.
I
don't know if I-
see.
Your Honor, am I finished?
Yes, you're
So,
finished.
March,
Thank you,
March
sir.
18th,
Yes,
Yeah.
sir,
March
thank you.
18th, same
Yes.
time,
Yes,
same
yes, 2
time?
o'clock. Yes, sir.
Thank you.
Thank you. 2 o'clock Eastern Standard Time.
Yes, thank you.
Thank you.
I just stopped you, Andrew.
All right. Thank you.
Okay, so Judge, do you wanna come off YouTube while we continue checking in?
Yes,
Or
yes,
okay,
yes.
okay. All right. Okay, Mr. Thomas, did I not send you? Yeah, I sent you an invite to room 3.
All right.
Okay. All right. Hi, Ms. Jameson.
Hello.
What a day. How are you? Okay, let me see. I see an attorney here. You know what? We're still on YouTube. Well, it's still on YouTube, so careful what you say. Okay, here's an attorney. Let's start with Mr. or Attorney Khan. Attorney Khan, good afternoon.
Good afternoon. How are you, Your Honor?
This is her clerk. What case number are you here on, or
Oh,
address?
I'm
please?
sorry. Hi.
That's okay.
Yeah, I'm here on 25018093093CH.
010, and which address?
And I'm only here on 8389 Gartner, 1814 Lawndale, and 1818 Lawndale.
Okay, so why don't you give the parcel number? Would that be easier? Oh, these are Mr. Thomas's case. You're muted, Mr. Thomas. So,
Thank
Mr.
you.
Khan, you said
Yes.
8389, that is parcel 1.
Yeah, 8389. Okay, yeah. So number 1, and then it looks like 2, 3, 4, and 5. So I'm on 8389 Gartner, 1814 Lawndale, and 1818 Lawndale.
Okay, got it.
Those are all me.
Yep. Do you need to talk to him in a breakout, Mr.
Very
Thomas?
briefly.
Okay, here's the invitation. Attorney
And then
Khan. Mhm.
for that West Grand Boulevard, we adjourn till 2:18.
Okay. West Grand Boulevard 218. Okay. So, Mr. Khan, here's an invitation for you going to room 4.
Okay.
Mr. Thomas, can you jump in?
I believe I can.
You can do it. I believe in you.
Oh,
Okay. February.
thank you. There we go. I got it.
There you go. Okay, so 218 on West Grand Boulevard. Okay. He's gone. Some attorney. Attorney Jones, good afternoon. 25-018-093. Okay, hi, sir. Which address are you here on?
1724 Euclid.
Yeah, this is Mr. Thomas also, attorney. Jones. Let's see. Mr. Jones, I'm going to put you back in the waiting room, but Attorney Thomas is the one that you're going to have a chat with, and he's already in a breakout with another 1724 West Euclid. So here he is. Mr. Thomas, Mr. Jones is here with regard to 1724 West Euclid. Do you need a breakout? Mr. Thomas, you're muted.
Yes, please.
Yes, okay. We're gonna go to, can you just jump back in room 4?
Yes.
There's your invitation, Mr. Jones. Okay, here's another Kevin McLean, that's a Peters Rock. Attorney Michael Rock, bring him in. Mr. Rock, good afternoon. Can you unmute, please? Attorney Rock? Okay, good afternoon, sir. Can you let us know what case number you're here on? I don't think he's hearing me. He's not ready. Mr. Rock, can you hear me? Can you hear us? We can't hear you. We can't hear you. While he's doing that, Miss Anderson and Miss Jameson, do you recognize any other names in the waiting room?
Yes, so
Okay, there
Sorry.
you are, Mr. Rock.
Okay.
Hi, what's the
Great.
case number?
All right, case number is goodness. Now the computer's decided to uh, all right, 25016123CH.
That's case number 7. That's my case. If you can please put me in the breakout room.
Yes, Mr. Rock, which address is it Cooper or Mendota?
Mendota.
Mendota. I'm going to invite you to brief.
Thank you.
Okay, you're welcome. I thought Mr. Khan. Can you join there, or do you need me to invite you, Miss Anderson?
I don't see the breakout rooms at the bottom like I did before.
Okay. Oh, you were in. Are you done with Mr. Ahmed?
He wants to stay. I was gonna adjourn his matter, but he wants it to be heard, so.
Okay, so here's your invite to 3.
One more thing, I saw
Oh.
April, can you hear me?
Yes.
April Newton is in the
Yes.
waiting room. She is here regarding case number 6.
Number 6. Do you need to talk to her?
No,
Okay, thank you.
thanks.
So I invited you to 3. Okay. Miss Jameson, the Zoom meeting had gotten locked. I don't know how that happened. Okay. Mr. Ahmed, I'm gonna put you back in the waiting room until the case is called. Kelvin Buckner. Kelvin Buckner, can you please unmute?
I'm here.
What address are you here with regard to, please?
Attorney Michael Rock is my attorney.
Oh,
in
okay.
16.
Okay, understood. Thank you.
Mhm.
That is with regard to Mendota?
Yes, that's
All
correct.
right. Thank you. And he knows you're here, Mr. Buckner? Mr. Buckner?
Yes, he knows I'm here.
Thank you. I'm gonna bring in Carla Brandon. Carla Brandon, can you unmute, please? Carla Brandon.
Hello.
Okay, hi. What address are you here with regard to?
4310 Cortland.
4310 Portland. One moment.
That's number 8.
Thank you. And that's Miss Anderson's. Okay, thank you, Miss Brandon.
Okay.
And then Douglas O'Neill. Mr. O'Neill, can you unmute, please? Douglas O'Neill, I need you to unmute. Okay, Mr. Jones, are you still going on the record today?
Yes, please.
Okay, so I'm gonna put you in the waiting room for just a few.
Thank you.
You're welcome. Mr. O'Neill, I need you to unmute. We'll come back. I'm bringing in a Francine Williams. Francine Williams, can you unmute, please? Francine Williams?
Can you hear me?
Yes, I hear you. What is the address, please?
4137 Van Dyke.
4137 Van Dyke. One moment, please.
That's case number 11.
Okay. All right. You do we need a chat, Mr. Thomas, with her? Yay, nay? Maybe not. Okay. Miss Williams, I'm going to bring you back when the court calls the case.
Okay, thank you.
You're welcome. Okay, I got a phone here. Inside. We have a state land bank case that we need to do before we even start with the QTs though. Okay, caller, I need you to unmute. I think. Let me try. Well, the caller's gone. Let me try O'Neill again. Okay, Mr. O'Neill?
Yeah,
Okay, what address are you here with regard to, please?
1400 South Beatrice.
1400 South Beatrice. One moment.
Yes. Okay.
That's number 9.
Number 9.
Parcel 4.
All right. Okay, thank you, and I'll bring you back when the court calls the case.
Okay, thank you.
Okay, I'm
You're
sorry.
welcome. So here's a Zoom user. Let me stop this video. Zoom user, can you unmute for me? What's your name? What is your name, please? You got to unmute again. You muted yourself. Okay,
Hello?
yes, hello. What is your name, please?
Ren Penlaki.
Just spell your last name.
PANLAQUI.
PANLAQUI. What is the address?
It's the the 36 Cooper Street.
36 Cooper Street,
Yep, 33, hang on, man. Let me type it down.
5360 Cooper? What is
Yes.
it? Is
That's
that
not-
it?
Hang on, let me get the correct one for you. It's not seen here. It's Cooper, East Cooper, parcel QT 521.
Yep, I
No, not
see it.
5360, ma'am.
I see it, thanks.
Yeah.
Number 7, right, Ms. Jamison?
Yes.
Mhm. Okay, did you say your last name? Say your last name for me, please.
Penlocky.
Tenlaki, okay.
Yes, ma'am.
Okay, I'm gonna put you in the waiting room until the case is called, okay?
Okay, sounds good. I'm trying to put in my video as well.
Yeah, you'll have the video when the judge comes out.
Okay.
Thank you.
Actually, the last name starts with a P, as in
Oh,
Paul.
P as in Paul, okay, thank you.
Thank you, ma'am.
Thank you for correcting me.
No,
Is that
awesome.
better? Thank you.
Yes. Thanks.
You're welcome. All right. I think that's everyone. And Mr. Rock and Ms. Anderson are still in the
Are the Flat Rock attorneys for the state land bank?
state. Mhm.
Okay,
Yes, yes, yes. All right, I'll be back.
thank you.
I'm sorry, Mr. Thomas, did you need to chat with anyone else? You're muted. Mr. Thomas, you can't win today.
My screen always shrinks down in
I
that mute
know,
button.
and you can't see.
Number 4 is going to be adjourned. I'm going to end up dismissing it.
Manner,
Correct.
so you want to put it where for now?
If you want to kick it out till March 18th, and then
Mhm.
we'll submit a dismissal.
Okay, done deal. Okay, any other adjournments?
No.
Mhm. Okay, Miss Anderson, did you have any adjournments?
Yes, so the,
I'm sorry, is Mr. Rock going forward? Is he going on the record this afternoon?
no, we're gonna adjourn that to February 4th.
That's in person.
Correct.
Okay. February 4. Okay, Mr. Rock, your client is in the waiting room. You will advise?
Yes, I will.
Okay,
It's
awesome.
February 4th at 3 p.m., correct?
Yes, sir.
Great, thank you.
All right, see you then.
Thank you very much.
Okay, Miss Anderson, any others?
Yes.
Okay.
Case number 9,
Which parcel?
10.
Pinehurst.
Yes, I'm gonna adjourn that to March 18th.
March 18th, okay.
And that's all I have.
Miss Jamison?
I'll be adjourning case number 5, 19310 Gallagher. And I would like to adjourn it to an April hearing date, but I know we don't have those yet.
Oh, so how about we say March 18, and then I'm not gonna let it go without it.
Okay.
Okay,
March
so
18.
March 18, and then we can kick it out more if need be.
Okay.
Do you have any others?
That's the only one that I'm adjourning.
Okay. All right, thanks. I'll be back.
Thank you. Kim?
Me?
No, I'm so sorry.
Okay.
Attorney Anderson. There's a Mr. Penlocky here. He's on 5360 Cooper, number 7.
Thank you.
And and Douglas O'Neill is on number 9, 1400 Beatrice.
Yes, ma'am.
And Andrew, I'm not sure if you spoke with Francine Williams is here on number 11, parcel
I've
16.
spoken with it too many times.
Oh, okay.
I know exactly what she wants, and
We're
just needs
we're
to.
still on YouTube.
Oh, all right.
And you're aware of Mr. Attorney David Jones for 1724 West Euclid?
Yep,
Oh, okay,
thank you.
thank you. I'm sorry, I was just trying to make sure we, in case you
No,
guys.
no,
weren't
I'm
aware.
grateful. Thank you.
Okay. And Kim, you spoke with Carla Brandon, right?
I don't need to.
Okay. Cool.
Did you see Lisa Baird in the waiting room at all? I didn't see earlier. Okay.
No.
Okay, Miss Clifton, who's doing the 26-361 Peters Road case?
There are several attorneys in the waiting room, several
Oh,
parties.
okay. Are they parties or attorney? Because if it's a motion, I just need the attorneys probably. Which, who's from the land, who's handling it from the land bank?
Attorney Benjamin Henry.
Okay.
Would you like for me to bring him in first? Because I see a
Yes, and then
lot of names I don't know.
okay, let's bring him in and determine who he needs on this
Okay.
motion. Mhm. Hi, Miss Anderson, how you doing?
I'm well. How are you?
Good, thanks.
Attorney Henry, oh, here it is, Judge.
Attorney Henry, who is also on this motion this afternoon? Which attorneys? Because we have people in the waiting room. I don't know who we're
Would you like
dealing
me to
with.
call the names of who's in the waiting room? Would that help?
Yes, I suspect that Kevin McLean,
Yes,
unless someone's appearing on his behalf, should be here.
he's here.
I know at least one of my clients, I believe at least one of my clients, Patrick Ennis, is
Yes.
maybe in the waiting room. And another one of my clients might be in the waiting room, maybe Joseph.
You
Joe
can text them.
Daly.
They're not going to come in. You can text them and tell them that we're on YouTube, that they can listen on YouTube. Unless yeah.
That's fine, right? Let me shoot them a real quick email.
Okay.
So we only want Attorney McLean.
That if that's he's the attorney on the hearing, and
Okay, it's just the two of you? It's
yes,
just the two
yes.
of you?
Well, I'm sorry. I don't know if Daniela Allison Yoakum is appearing for the state, or if they had filed an appearance as well.
I don't see that person.
Whether or not they're going to appear, I don't know.
Okay. No one by that name is in the waiting room.
Right, and everyone else has been assigned, correct, Ms. Clifton?
Yes.
Okay. Okay, when you're ready.
Okay. Calling case number 25013-229-CH State Land Bank Authority versus 26361 Peters Road, Flat Rock, Michigan.
Council appearances for the record?
Good afternoon, Your Honor. Benjamin Henry appearing on behalf of the State Land Bank Authority.
And good afternoon, Your Honor. Kevin McLean appearing on behalf of Daily Real Estate Services Incorporated. Your Honor, I believe that my client, Joseph Daly, was in the waiting room. I don't know if he's been admitted or not.
No, he won't be admitted. He can listen to it on Zoom. I'm sorry, the YouTube Live. You can shoot him if you like a note indicating he can view this on YouTube Live.
I'll let him know now. Thank you.
Thank you. Okay, so Mr. McLean, whenever you're ready. This
Yes.
is your motion. Mhm.
Yes, thank you, Your Honor. Just as a brief refresher, today is date time for a hearing in this matter. We had last appeared on December 19th on my motion to set aside the judgment that had been entered at the October 17th hearing, which my client did not receive notice of. At the close of that hearing, Your Honor set this matter for a hearing, from my understanding, on plaintiff's petition. However, since then, I had filed my objections, which were filed on January 20th and handed over to your court. I did receive some responses from brother counsel in relation to those objections yesterday at about 1:30. In reviewing my client's rights, titles, and interest in subject properties, our objections to plaintiff's petition focus on two of the three properties, which have been referred in my objections to the Woodhaven 1 property and the Flat Rock 2 property. There is no real quick and easy way to move through the objections and the responses filed by brother counsel. However, I'll try to do so, keeping in mind the court's time. In the responses from plaintiff, they address the issue of property taxes, and there's two primary arguments that I surmised: that Daily Real Estate does not claim to have paid any property taxes on any of these parcels, and that the FOIA request responses from the Wayne County Treasurer's Office and the cities of Woodhaven and Flat Rock support plaintiff's position that it has a superior claim of title over Daily Real Estate. Plaintiff then states that these objections related to the property taxes that were filed in our that were filed with the court should be ignored. However, in my opinion, these arguments ignore certain facts and make some inaccurate assumptions. First, Daily Real Estate has paid property taxes for these parcels, and in submitting its FOIA request to the Wayne County Treasurer's Office, it specifically requested records of both the foreclosure packets, which includes proofs of notice, personal visits, tax statements, and delinquent tax history, as well as also specifically requesting real property tax history and payment records from 1990 through the present, including who made the payment. This was done because Daily Real Estate is no longer in possession of documentary evidence of having paid those property taxes from roughly 30 years ago. The responses from the FOIA request to the Wayne County Treasurer's Office related to the foreclosure packet state, quote, after a diligent search of the requested records, we've determined and certified the records do not exist within the Wayne County Treasurer's Office, and these properties have no history of foreclosure. The response from the Wayne County Treasurer's Office related to the payment history of the taxes states, quote, after a diligent search of the requested records, we have determined and certified the records do not exist within the Wayne County Treasurer's Office. Brother counsel had submitted some FOIA requests that were attached to his response to the objections, in which the city of Flat Rock responded by showing only a history of the amount of property taxes assessed. However, it didn't show any records of payments or who made any payments or whose responsibilities the taxes may have been during certain years. Woodhaven's response to the FOIA request stated that the city of Woodhaven doesn't have any information to provide. It's my opinion to ignore this property tax issue is to ignore the history of how either of these parties ever obtained any of their alleged interest in the properties. If those are ignored, it would also ignore any defects of the foreclosure process conducted by the state, which we believe were invalid and therefore should be voided, which severely affects the state's position that it has a superior claim of title. In fact, the Wayne County Treasurer's Office, in that response to the FOIA request, stated that there hadn't been any foreclosures whatsoever. The fact that the Wayne County Treasurer's Office, the cities of Woodhaven and Flat Rock, and presumably the state of Michigan don't have any records related to those properties is not a fact that should be ignored or construed favorably to plaintiff's position. After all, as stated in our objections, the tax foreclosure process during the relevant periods for the properties subject to this petition, those were completed purely administratively. It was basically a paperwork foreclosure. And in doing so, the Michigan Supreme Court, as well as the US Supreme Court, has consistently held that due to such and the interest of property potentially being removed from someone with an interest in that property requires strict compliance with notice of parties claiming an interest in those statutory procedures that were in effect. It's undisputed that the property taxes ceased being assessed at some point for these properties, and it is the state or county officials that were responsible to provide the municipalities instructions to remove the properties from the tax rolls, and not my client's responsibility. If the state or county did so erroneously, that's something that they must address and overcome. Moreover, it's also the state and county's responsibility to provide notice to those claiming an interest in the properties that were being foreclosed or subject to foreclosure unless otherwise redeemed. It's clear from the lack of public records related to these properties, that none of the necessary notices were provided to anyone claiming an interest to the properties. And those notices required are not limited solely to the show cause hearing notices that have been attached to our objections pursuant to MCL 211.131E. Rather, that was just one of the many notices necessary to strictly comply with the statutes controlling foreclosures at the time. There is some history in these properties and litigation that my client had filed in the early 2000s. My client was represented by Don Howard, who presumably focused his entire area of practice on this area of the law. And in doing so, there was an action to quiet title that's been attached to our objections at Exhibit 18. This was filed in January of 2002, and it looks like service was accomplished sometime January, February, March of 2002. In that lawsuit, the state of Michigan, as well as the Michigan Department of Natural Resources, were named as defendants. And there was an appearance filed by a Ronald Chwang, who was working for the Michigan Attorney General's office at the time. While the litigation was pending, my client Joseph Daly, as well as his counsel, took a trip out to Lansing to discuss these matters and the tax issues and the properties in their entirety. It was at that time, at that meeting, that it was discussed that the state didn't disclaim any interest that Daly may have had at that time. The state also did not relinquish any alleged interest that they had at that time. It was discussed that basically the properties had been abandoned by the previous owner, that had been foreclosed, and that both the state as well as my client would work to try to find a suitable or potential purchaser. And if that came to fruition, the parties would then discuss with each other what respective rights and division of any potential proceeds upon a successful sale prior to closing. Those judgments of quiet title were included merely to help illustrate the history of the title of these properties and to show the efforts that Daly Real Estate employed to clear the title through the courts. While the language in the judgments quieting title may be ambiguous, certainly it's unambiguous that the state was at that time in early 2002 notified of Daly's alleged interest in the properties if it had not somehow already been so. There's no language in the judgment stating that the state or any of its predecessor agencies have superior title over Daly. And upon receiving notice of the action of quiet title, the state and its agencies were effectively in the same exact position as Daly regarding any of their respective rights, title, or interest in the properties. Neither party did anything or was able to provide a potential purchaser until recently, in which the state has apparently entered into an option purchase agreement with an out-of-state entity. Regarding lack of notice in response to plaintiff's filing related to our objections, plaintiff assumes that whomever allegedly signed for the certified mail of the show cause hearing notice and affidavit unquestionably did so on behalf of Petroleum, and therefore the notice was proper. What this fails to take into account is who actually signed these certified mailings. The certified mailing to the Woodhaven property was improperly addressed, and it was to an address that did not exist. How USPS would deliver something to an address that doesn't exist, nobody here could possibly know, but it's basically plaintiff's position that because it was signed for, it had to have been signed for somebody on behalf of Petroleum. There's no, on the certified mailing, there's no printed name of who signed for it. And there's solely signatures on any of those notice affidavits, as I've referred to them in our objection. Plaintiff argues that by Daly not raising any objections to the Flat Rock 1 property, that must mean that Daly is satisfied with the signatures on all three of these notice affidavits that have been discovered and that were sent to Petroleum. And despite plaintiff not providing any sufficient evidentiary basis, that the same person signed all 3 notice affidavits, and that was valid and proper notice. This is a mischaracterization of Daley's arguments here, and the sole reason that it did not file any objections related to the Flat Rock 1 property was because the only instruments of conveyance that supported any position on that Flat Rock 1 property were the judgments quieting title, whereas these other properties, there are certificates, deeds, and judgments to quiet title, as well as everything else that has been filed. Plaintiff argues in its response to our objections that pursuant to MRE 901 B2 and 3, Your Honor can confirm the authenticity of the handwriting samples. MRE 901 B2 and B3 state that to satisfy the requirement for authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what its proponent claims it is through B2, non-expert testimony about handwriting, a non-expert's opinion that handwriting is genuine based on a familiarity with it that was not acquired for the current litigation, and B3, comparison by an expert witness, or in this case, a trier of fact, in which a comparison with an authenticated specimen by an expert witness or trier of fact is present. Related to the B2 argument, any familiarity would be acquired solely from the current litigation, and related to the B3 argument, there's no authenticated specimen by an expert witness or a trier of fact to compare to. Plaintiff states that the inaccurate address on the notice affidavit for the Woodhaven property, which as we've discussed is not a valid address, dismantles any argument that Daley could make because it could not have been delivered to that address, so it must have been signed for someone on behalf of Petroleum. This argument to me effectively states that if a notice affidavit was sent to an inaccurate address or person, but it is signed for, regardless of whether anyone can ascertain who signed for it, it must be construed to have been provided notice in strict compliance with the statutes, which the courts have consistently ruled contrary to. Plaintiff is attempting to argue that Petroleum received actual notice of the show cause hearing purely based upon its self-serving assumptions and without providing any evidence sufficient to support that position. Regarding notice of the Flat Rock 2 property, the affidavit which plaintiff attacks in our objection has been presented to the court solely based upon an employee of my client's recollection, information, and belief regarding the process that she employed in citing for certified mailings on behalf of her employer. Daley is simply pointing out to the court for her review of the document discovered in its investigation of these properties. Obviously, something from that long ago, no one is going to specifically recall, but it's only based upon her reviewing. Plaintiff discusses standing in its response to our objections related to that argument. What logically does not follow is why the state would provide a notice affidavit to Daley for the Flat Rock 2 property, but not the Woodhaven property. Additionally, as plaintiff asserts in its response, quote, it is Petroleum Specialties that must come to court to argue it receiving inadequate notice of the tax foreclosure, end quote. If that is so, why was Petroleum not named as an interested party and served notice for these proceedings? Plaintiff cannot argue out of both sides of its mouth on that issue. Daley received its interest from First Union National Bank, and either one of those parties should have provided some sort of notice affidavit of the foreclosure of subsequent tax years, such as Petroleum had. Certainly the state and the county treasurer's office had actual notice that Daley and or First Union Bank had a valid interest in the property based upon its purchase of the 1992 taxes, since the interest which plaintiff is relying on is from the 1993 taxes. Daley obtained its interest from the foreclosure of taxes that Petroleum was responsible for, and then Daley quieted the subject properties related to Petroleum. Daley in these circumstances had standing based upon where its interest of the property derived from and its lack of notice and actions taken after acquiring such. There's a notation about adverse possession in plaintiff's response, and plaintiff argues that it has complied with all the elements of adverse possession and that Daley has not, apparently based solely upon its assertion that it has without any facts or evidence. There is a note regarding latches in which plaintiff cites Samasco v. Harrison, a Michigan Court of Appeals ruling from 1969. However, Samasco was overruled by the Court of Appeals in 1987, in which the Court of Appeals held that latches was not an excuse of a party's improper notice, and the court specifically noted that Samasco was wrongly decided on the issue of latches. Regarding the statute of limitations argument in plaintiff's response, I believe it to be a moot issue regarding the Woodhaven and Flat Rock 2 properties, since the period for redemption never began tolling whatsoever based upon the defective notice as we have pled. Simply put, the meter never began running for the redemption purposes due to the state's failure to strictly comply with the necessary notice requirements. Obviously, I know that was long-winded and I know that it's late in the afternoon, so I do appreciate the court for allowing me to get through that. In sum, this is not a simple foreclosure case. I understand that the state has a job to do as it relates to these properties and what it believes is best for the state and the local communities related to these properties, but this is not a simple cut and dry issue. And I would ask the court to take all of that into account and either order that defendant or interested party Daley Real Estate does have a superior claim for the two parcels that we have objected to, or alternatively, due to the complexity of this, consider appointing a special master to move through these objections to a resolution of the parties.
Thank you, Your Honor. This is a simple case. The payment of taxes issues has nothing to do with title. Doesn't matter who's paying taxes. That doesn't create a title interest. That smokescreen, red herring, doesn't make any difference. What Daley Real Estate needs to do today is establish that it has some superior recorded title interest in the properties. So glad to see that they have conceded on Flat Rock 1. So we'll ask the court to order that we can submit a judgment, at least with regard to Flat Rock 1.
Okay, and that being said, let's nip that in the bud now. The court will grant the relief as it relates to Flat Rock 1, what's the address? Is that 263?
They're all kind of under the same street
address. So do they have parcel numbers?
They have parcel numbers, and that is the one, and I'll Mr. McLean can confirm. I refer to it as ending in 0001.
Okay, so that's 58-081-99-0001, correct? Is that the right one? Is that the right one?
Let me double check.
-000 just to end it, Your Honor, but that is the correct one.
Okay.
Yes, 58-081-99-0001-000.
Okay, so the court will enter the order as it relates to that one. Mr. Henry will at least resolve that.
Thank you, Your Honor.
Okay.
With regard to Flat Rock 2, again, the state land bank's interest is derived from a treasurer's deed for 1998 taxes that was recorded on January 10th of 2000. Daley Real Estate, therefore, needs to establish some title interest that exists that is either superior to that, or they need to somehow go back in time and try to negate that foreclosure process, which they've tried to do. With regard to title interest, nothing that they have presented with regard to the judgments, their assignments, the deeds, all of that is specifically related to tax foreclosures for 1992 and 1993 taxes. Therefore, a subsequent tax foreclosure, 1998, extinguished those interests and vested the property in the state when nobody else came forward and bid on it. The recorded judgment, no mention of extinguishing any interest of anyone other than I think it's Mr. Fleischman. And then the unrecorded judgment, which again, unrecorded, never made it, whatever their excuses are, never made it into the record. You know, does it name the state? Yes. Does it enter any type of judgment against the state? No. Does their verified complaint identify any interest of the state? No. So you know, and by the time that was filed, and that's an 02 case, our deed was of record. They should have named us. They should have identified us. Whatever happened in that case did not extinguish our interest. Again, here, Daily Real Estate is challenging the notice affidavit itself. And as they pointed out, they're of course now trying to clarify that we're not claiming that we went back in time, that someone went back in time and recorded this. It doesn't change the fact that Daily Real Estate signed for that. And they're trying to convert a sloppily executed 01 into an 04. It couldn't have happened. It could not be that Daily Real Estate signed for that on June 12th, 2004. But that the affidavit with the certified mailing notice was filed on May 2nd of 2002. And again, we do rely upon the arguments that we made here, which is Daily Real Estate never paid no evidence that they've ever paid any taxes, right? Well, they need to produce evidence that they've paid taxes. They've never had possession control, anything. We've got our 15 years, well beyond our 15 years. I don't believe, and I could double check and I'll submit if you want, I don't believe the Samasco case was overruled. I know it was questioned, but I don't believe that it was specifically overruled. I think there's a footnote speaking to, we question that holding. But certainly the 1-year statute of limitations that we cited to the Haywood case, if it's, you know, the Haywood case says 1-year statute of limitations, and the old General Property Tax Act gave everyone a 1-year period to redeem after the tax sale, or 18 months if it went to the state. And so that makes sense because here, Daily Real Estate has submitted an affidavit saying, yeah, we got notice. We got that notice. Well, they're saying they got it in 2004, but they got it. They should have done something. What have they been doing for 22 years? The time to challenge it is when they admit they received at least some notice. So if they received it in 2004, they should have done something by 2006. So again, we don't think that we contend strongly. They haven't established any title interest in Flat Rock 2, and that judgment quieting title should be entered in the state on that one as well. And then unless the court has comments or questions, I'll move on to Woodhaven, what I've deemed as 08, but we'll just call
So
the
let's deal with
certainly, Your Honor.
with Flat Rock 2, which is the parcel ID for Flat Rock 2, is that the 5808199-0002-000?
Yes, Your Honor.
Okay, thank you. Any reply, Mr. McLean?
Just briefly, Your Honor, obviously it would rely upon the objections that were filed as well as the support to those. I guess I'm trying to understand specifically what plaintiff's argument is.
I think let me make sure I understand. I think what he's saying is that, you know, in terms of irrespective of who paid the taxes, that you have to show, and that there isn't been a showing that you have a superior title in Flat Rock 2. Did I break that down, Mr. Henry?
That's the simplest way to state it, Your Honor.
Okay. Yeah, the simplistically.
So in order to do that, we have to look at how the state has obtained their title. Is that correct, Your Honor?
No, they were wait, it's my understanding that they were the last, you're trying to take, saying that you're superior to them. Mr. Henry, how long had the state had that interest in the title, in the property?
Flat Rock 2, non-payment of 1998 taxes, foreclosure for 1998 taxes. We recorded our interest on January 10th of 2000. So unless Daily Real Estate can produce some valid recorded interest after January 10th, 2000, they're pointing to their one recorded judgment, which again doesn't name the state, doesn't enter a judgment against the state. That does nothing with regard to the state's interest. What have they got?
So I unfortunately know too much about the tax lien sale system from the 90s based upon my review of this case. The state treasurer's deed was sold, the interest in which plaintiff relies That was for the 1995 taxes that was sold at the 1998 tax sale. The process got changed on these foreclosures almost entirely because of how long foreclosures were taking the state and the counties during this period of time. It inhibited prospective investors or purchasers from purchasing these properties at tax sales because of the potentially unmarketable title in which they would be paying for. And so in looking at a superior claim, it would be my opinion that we have to determine how the state obtained theirs. So the state is indicating really nothing related to the 1992 or 1993 tax sales is relevant because we get our interest from the state treasurer's deed, which really derives from the 1995 tax sale or the 1998 tax sale for the 1995 taxes. It is our position that the state did not foreclose upon those adequately and in strict compliance with the foreclosure proceedings that were in effect and must be construed based upon those statutes at the time that these relevant events took place.
Okay, well, let me interrupt you. Okay, so we even if you're arguing that you're saying that it wasn't properly effectuated as a result of the 1995 taxes that went to sheriff's sale in 1998, your client didn't come into play until when?
My client, the recorded interest really began, I believe, around 2000, sometime in that period. However, that was based upon the 1992 or 1993 taxes that they
But
got.
we're not talking about that. We said that that didn't come into play. We're talking about this case originated as a result of the 1995 taxes, which resulted in the sale in 1998. So and that's what my understanding is. That's what I thought you just said. That we're talking about the sale of the tax year of 1995, whereby it went to sheriff's sale in 1998. Correct me if I'm wrong.
No, you're exactly correct, Your Honor.
Okay,
And
so that being said, that's what we're relying on. We have to have a period of time that we're relying on. That's what we're relying on. Because I thought you said you're trying to interject the 1992, but really the 1992 doesn't have a bearing, and correct me if I'm wrong, on the tax year, the 1995 tax year, which resulted in the the alleged foreclosure, the foreclosure, and the sale in 1998.
yes, you're correct. And part of the, in my opinion, complexity of this is that my client indicates that he had continued to pay taxes for these two parcels.
Okay,
That is specifically why we have.
okay, let me interrupt you right there because what Mr. Henry had indicated was that in terms of they may have paid taxes, but did they in fact have any title? Just because you're paying, a lot of people pay taxes, but did they have any title in that property? When did they?
The title, from my understanding, wouldn't be effectuated until there was a tax deed issued and recorded, which happened typically sometime around 5 to 6 years after the redemption period expired.
Okay,
And
stop, hold there. Mr. Henry, when was when was the title recorded relative to this property?
The state's title?
Yeah.
Well, with regard to this one, our interest with regard to Flat Rock 2 was recorded January 10th of 2000.
January 10th of 2000. Okay, so Mr. McLean, where's that goes back to my question. When are you asserting that not paying taxes, but in terms of a recorded deed or title, we have the state land bank recording theirs January 10th, 2000. When was there any recording on behalf of your client?
yes, give me one moment, Your Honor.
Mr. Henry, do you have that information? Do you know? Somebody?
Yeah, I have it all here.
Because, yeah, because the thing is to me, you look at when the property was recorded, because as I indicated, paying taxes does not make a deed or a title or a vested interest. Unless, you got some, the only other way is some adverse possession going on and you've had it for a significant period of time. That, just because you pay taxes does not mean that it's vested in you. So that's my issue. We have the state land banks deed recorded January 10th, 2000. And if your client if there's a deed, there's just because they're paying taxes, that doesn't vest in them.
Sure, there is a deed that was recorded related to that specific Flat Rock property on May 30th of 2000. There is also a tax deed that was recorded on September 18th of 2000. There is
What was that? You said September what?
September 18th of 2000. There is an addendum to the assignment of certificate of purchase that was recorded on June 7th of 2001. And there is another deed recorded October 11th, 2001.
And just to be clear, Your Honor, each one of those conveyances just listed is specific, such as the May 30th, 2000. This instrument conveys only that right, title, and interest to the grantor, Daily Real Estate, acquired through tax deed number 02889 for the 1992 taxes. So, okay, they finally got a deed years later and recorded it, again, still even after ours. The interest they got is only that specifically related to what they took for 1992 non-payment taxes. If you go and you buy a tax deed during this time period, does it take a while to go through the system? Yes, there's a reason that the General Property Tax Act was amended. But do you have to then, as the new owner of the property, pay the taxes to avoid subsequent tax sales? Yes. And the fact that we have a state treasurer's deed is in my opinion, recorded prima facie evidence that it says title became absolute in the state of Michigan by court decree of the circuit court of the county. These still went through the court. Now, there was a longer redemption period after that, but everything they're arguing about relates back to only 92 or 93 taxes.
So because as he's indicated, I understand you recorded these and it takes a while to get through the system and they've corrected things so it wouldn't take a while, but it's clear on its face that only relates to the 92 taxes. We're talking about the 95 taxes that whereby it was recorded. I think you said January
10th of 2000, Your Honor.
Right, January 10th, 2000. And that was related to the 95 taxes that were foreclosed on in 98. So that, your documentation only relates to the 92 taxes. So that's why, and I said, that's really not relevant here because it doesn't relate to there's nothing here that's relating to the 95 taxes and the recording and the foreclosure in 98, which was recorded in 2000. And it's clear. It's clear on his face that it says what you articulated was relative to the 92 taxes.
And using the same argument about, well, that would have been for taxes 3 years earlier, and that was for 1989 taxes.
Yeah. So they didn't respond to the 95 tax foreclosure. And go ahead, Mr. Henry, I'm sorry.
Again, we can argue about the date. They admit they received the notice. They didn't do anything.
If I may, Your Honor, the state treasurer's deed. Yes, it may state language regarding a court decree or judicial proceeding. These proceedings never went to court. It was purely administrative, which is why the court has again and again and again ruled that due process rights require strict compliance as it relates to notice. If my client purchased the 1992 taxes at the 1995 tax sale, surely the state and county had noticed that they had an interest in the party.
But wait. But see, you're to me, you're still mixing apples and oranges. You're talking about the 1992 taxes. And correct me if I'm wrong, I thought that relative to where we are, we're talking about the 1995 taxes. It- Mr. Benjamin, Mr. Henry, am I not interpreting this right?
That's how I interpret it. That's my argument, Your Honor. At the latest, then our interest stems from foreclosure in 1995 taxes. Everything that they have is related to 1992, 1993 tax foreclosure, which, okay, well, let's accept the 3 years. That means it was even earlier taxes.
But it's not relative to the basis why we're here today.
What recorded interest do they have? This idea that, well, they would have known that, yeah, you're right. But when we purchased and we don't purchase, right? These come to the state because nobody else will buy them. These are the property. That's how the state gets them, right? So when we got title at the 98 tax sale, we didn't, again, they want to argue, well, you can't prove that we got proper notice. Look, this has been recorded for 30 years, right? This should be essentially prima facie evidence that the things that needed to be done were done. They admit that they got notice, right? But I don't have to look back. Okay, well, they purchased somebody and through assignments, it wasn't even necessarily dealer real estate, purchased at the 1992 tax sale, but they didn't pay the taxes. Whoever purchased, they didn't pay the taxes, so they're up for it's up for sale again.
But my client's position is that he continued to pay taxes, and with the county and nobody having records of anything related to these properties, should we just assume that everything was done properly by the state then? Because
Your Honor, even putting aside the fact that they haven't presented any evidence that taxes were paid, and that the information that everybody has produced is that at some point, and they've admitted, taxes stopped being assessed. My client will state, my client contends, there's no affidavit, there's no proof of payment of taxes. Taxes weren't assessed because it was titled in the name of the state, and the state doesn't pay itself taxes.
my client was here this afternoon ready to attest to this because I thought it would be more prudent to have somebody who was a party to these properties or had an interest in these properties to provide that to the court himself.
But that's basically self-serving, and the thing is no one has any documentary evidence, and to me that's not enough to persuade the court, a self-serving statement that you paid the taxes. But then, like I said, all the paperwork you have goes back to the 1992 and prior tax years, and we're talking about 1998, and here we are in 2026. And if nothing, if there was an issue and I could present that basically if there was an issue, there's been an adverse sort of possession argument here because it's been 30 years.
But nobody has been in possession of that property, Your Honor. That property was enclosed by a 6-foot barbed wire fence. I drove by it last weekend, and apparently somebody has just recently gone and either cut a hole through the fence or opened a gate there. Nobody has possessed this property. The plaintiff has not had open notorious possession of the property by exhibiting any sort of control on the actual property.
Well, wait, let me interrupt you
just solely from the state treasury deed.
Let me interrupt you there. Who put up the fence?
That
Mr.
was
Henry,
the federal government.
I don't know exactly who put the fence up, Your Honor.
But
certainly, right, everybody's possession, other than the state or the federal government. I guess I can argue with the federal government about whether or not they've had possession and control. But everybody else has been excluded from that property because it's a contaminated area. There's millions of dollars worth of state and federal liens on it.
Federal liens have been extinguished, And the reason that nothing was done is because my client did go with his then counsel to discuss these properties and how to resolve these in 2002 when they filed the action to quiet title in which the state was named. Yes, that judgment was not recorded. It is certainly certified by the court. There's, I wasn't going to go and run after filing that and go file it with the Register of Deeds and further convolute this. Obviously that serves no purpose. All I can say, obviously I was not there, but at that time, the Register of Deeds was located in the basement, right where judgments and these legal instruments get certified, and he took it over there to be recorded. It wasn't recorded. We don't deny that. The reality is that at the meeting in Lansing between my client, his counsel, and the Attorney General's office through one of the attorneys working there at the time, it was discussed, yeah, okay, there are competing interests in this property. The state indicated they weren't going to relinquish an interest. My client wasn't going to relinquish an interest. There were several lawsuits filed trying to name other parties to clear title. And at the close of that meeting, it was discussed. Obviously, the state's position has changed on this issue based upon what has happened in these proceedings. However, the discussion closed by stating that let's both work to try to find potential purchasers. When we find a potential purchaser, we'll resolve what's going to happen with any potential proceeds prior to closing. And my client said, well, I would like to try to get on the property to do anything like that. And they advised against it based upon the contamination.
Your Honor, I hate to cut in, but in Michigan, the statute of fraud says that interest in real estate must be in writing.
Yeah.
You can talk about all the meetings and promises and everything else that you want. It doesn't make a difference. That's why this is a simple case. What's
Right.
the title?
I think, like I said, from the inception, the last thing that we have here, we've got the recorded deed as it relates to the 1995 taxes from the foreclosure that took place in 1998 was recorded by the state. That's, and as you indicated, Mr. McLean, what the interest you have is relative to the property taxes that were in effect in 92 based upon really the 1989 tax year. So it has no relevancy here. So I'm at this point in time, I'm prepared to deny the objections, and the court previously entered the quiet title. When did I enter that? On December 9th? No, wait, when did I enter it?
It was on October 19th, Your Honor.
October 19th, yes.
If I may just briefly.
I don't know. I've given you enough time. I've got a whole 10 cases. You
2
get 2
minutes,
minutes. Two minutes.
The documents for the state treasurer's deeds are, okay, so it's a position that these were recorded last. So that's what we have to dismantle. And if the processes in order that the state received the state treasurer's deed were ineffective and not in compliance with the statutes, that does dismantle their interest. And that is what our position is, that these notices were not proper. And for an administrative foreclosure, there was no judicial hearing. For an administrative foreclosure, those notices and the process in general has to be strictly complied with based upon the potential for someone's property to be deprived of.
Okay, thank you. That's it. Mr. Benjamin, I'm sorry, Mr. Henry, I'm looking.
It's okay, Your Honor.
Go ahead, Mr. Henry, briefly. If you have anything you want to add. If you don't, I'm fine. He made a record. If you want to leave it at that, I'm fine.
Well, unless the court needs something, I get my final thought with that, and it goes towards the next one as well, which is Daily Real Estate doesn't have standing to challenge notice to other parties. So if their challenge has to do with petroleum specialties, fine. With regard to Flat Rock 2, they admit to receiving notice.
Okay, thank you. Thank you. Okay, so I've ruled. Now where are we going?
I'm going to go to Woodhaven, just the Woodhaven property.
Well, okay.
Again, briefly, treasurer's deed from the 1996 tax sale for the state recorded April 3rd, 1998. So this is where the state land bank is claiming its interest. The only argument I understood from Daily Real Estate on this was that Petroleum Specialties did not receive proper notice, right? So they're pointing to the certified mailing card that has the improper address on it. So again, I'll just restate, they don't have standing, and that's pursuant to, it's in my brief, Frey versus Scott. They don't have standing to argue notice on behalf of a third party. So Petroleum Specialties needs to come in here and argue that. And I will reassert that I think the court can look at the 3 certified mailings, see that these are the same signature.
What exhibit is that?
Well, do you have my brief, Your Honor?
Your response brief.
My response?
Yes.
Because I've cut and pasted from those exhibits, and those are exhibits G, H, and I. But
right, because I have them in paper. I have them on paper.
On pages 6 and 7 of my reply brief, Your Honor, I've cut and pasted those 3 so that they're in close proximity and the court can look at them. And I would argue that those are the same signature. A statement was made earlier about nobody here could contend how a piece of mail improperly addressed could get to the proper case. I will, Judge. I'll put some faith in the United States Postal Service to know that, oh, hey, I know where Petroleum Specialties is. There is no 6361 Peters Road, but I know where this goes. And as I pointed out in my brief, with regard to adequate notice, some of the documents that Daily Real Estate submitted had Petroleum Specialties simply listing its address as Peters Road. Again, with the standing issue and with the court's review of those signatures, I think the court could rule, I argue that the court can rule that there's evidence that they actually received notice.
Briefly, Mr. McLean.
Yes, the case law is clear that even a minor defect can affect notice and then can void the area in which the state is indicating it derives it in its interest. There is
But you say it can, but it doesn't, it's not mandated. It can.
Strict compliance is what the court has held consistently as it relates to notice. And there's case law that I provided in my objections. It's without question that it was addressed to the wrong place. Petroleum, the lien affecting the property, which
okay, but let me stop you right there. You're talking about petroleum. You can't represent the interests of petroleum. How are you representing?
Petroleum is the entity in which we obtained a judgment quieting title from the 2000.
Okay, that's fine, but that's not you though.
Case.
That's
And
not you. You can't talk about petroleum standing. You're not their notice. You're not in a position to represent their interests.
well, at the time in which the state treasurer's deed for this property was recorded, my client had an interest via the tax sale the previous year.
You're talking about at the time. I'm talking about right now. You don't have the interest. You can't represent their interest now. I don't know what happened 30 years ago, 28 years ago, but we're talking about 2026. And there's no evidence that you have any right to act on their behalf. You don't have standing to talk on behalf of petroleum. You don't. So
if we purchase an interest from the tax sale the year prior, the state and county know of somebody who has a potential interest.
Okay, but that's not you. You're only way
it was at that time.
But the thing is, you still can't come forward and talk about the interest of petroleum. I don't care what you purchase. You can't talk about petroleum's interest. You're not here to represent their interests, so you can't. You don't have standing. You don't.
To that same point, why wasn't petroleum named?
That's not for me to determine. You don't represent petroleum, so I cannot. That's it. So relative to our last one is relative to. That's the what's the property? What is that?
I think that the wrong parcel ID was indicated. It's the first one on the case caption. I believe that it's actually 59-08099.
That's correct. My case caption has a typo.
Right. So we're talking about 59-08099-0008000.
Correct.
Okay.
Your Honor, I just want to understand one thing, if nothing else, but for education purposes. If petroleum was not properly foreclosed upon, then how has the state perfected its interest through the state treasurer's deed for this property?
Ms. Henry? Any response?
My response to that would be they're just stating that, hey, there has to be strict compliance. I mean, that's just a notice argument. That's just another notice argument. You know, it would have to be Petroleum Specialties to come in here and say, like the one case that they cited to, and I don't remember off the top of my head the citation, Your Honor, which was in that case, that party came to court and said, hey, I know that the state received a signed certified mailing back. But here's an affidavit, and here are statements, and here are people from our company who say, we didn't get it. Petroleum Specialties is the only one to do that. And with regard to standing, Your Honor, just again, real briefly, the idea of standing is that you are the party who is in the best position to argue in favor of the argument that needs to be made. Why would Petroleum Specialties want to come to court and argue that no, we do still claim title to that property despite millions of dollars worth of state and federal tax liens? Clearly, Petroleum Specialty, as Daily Real Estate speculated, abandoned that property due to the liability. They probably happily signed for that and left town.
That obviously making some assumptions, and the statute of limitations likely for these liens may have already run, which is exactly why the state appears to be entering into a contract to sell this to an out-of-state energy company, because they know that they aren't going to have any liability related to those liens that have run the course.
Those liens have not run, Your Honor. Those liens are still active. We can deal with the liens because they're our liens. We're the state.
Okay.
And what the state does is unquestioned, apparently, whether it's record keeping or anything related to these foreclosures. Wayne County Treasurer's Office certifies there's no history of foreclosures. But let's assume that these foreclosures did take place and that they were proper.
Okay, but like I said, relative to this, Mr. McLean, in terms of the representation, you're not properly representing petroleum, so we cannot go down that road, unfortunately.
So I guess if there's a judgment entered in favor of the state related to this, it's subject to petroleum's rights that
petroleum, you said you said petroleum, so yes. Based on a representation placed on the record, the court will maintain the order that was entered October 19th in this matter as it relates to, again, 590809900008-000. And I think that's the last one, is it not?
It is, Your Honor, and just to make sure that I'm submitting what the court needs. I interpret the prior judgment to have been set aside based upon their request set aside. So
wait, now when did I see in terms of it was set aside
following the December 19th hearing, Your Honor.
So I did set it aside, or was it subject to?
It was set aside.
Yeah. It was a very basic order, which
okay.
Was
all right.
So my proposal would be to resubmit a new judgment.
Right.
Rather than just I could call it a reinstatement, whatever the court wants.
I say because we didn't put new arguments on the records, that we reinstate the judgment of October, because that's where the arguments flowed from, right? But if in terms of, because if I reinstate them and the orders still come, and if they want to do an appeal, they would still have the appeal from today's date, even though we're reinstating the orders.
So it would be a simple order reinstating the judgment entered on October
19th.
Which I can do. But again, Mr. McLean, you have objections to that. I know you have objections overall, but to just the process.
Well, I guess I appreciate everyone's time. I appreciate Mr. Henry as well as the court's time. I guess I would just want clarification of, so if this resubmission of that judgment would then be reviewed by the court, presumably signed and entered by the court, which then begins any
appellate, yes. Yeah, once the court signs this order, because what happened, we filed them, we set them aside, you objected, and based on the arguments, the court is reinstating them.
Sure.
As the arguments were presented for the court to grant the relief on October 19th, but your appellate review period begins to run when the court enters this order.
Perfect. I appreciate
Okay.
that. And I guess one housekeeping issue is, well, I guess it could relate to this resubmission of that order, is if the ruling from the court today is that the state has superior interest to Daily for all three of these properties, is there something that could be included in that stating that Daily Real Estate is released of any potential liability for any of these environmental liens that apparently still may be in effect?
Well, again, the judgment quiets title and extinguishes any interest. So in my opinion, I don't know that the court could
Fashion
rule
that,
on.
no, because we didn't do that. But if it extinguishes any interest, then that's sort of black and white. Your interest is being extinguished. So yeah, because that's asking more of me than what I've dealt with. So I'm not prepared to do that. But just you can say it extinguishes their interest. Mr. Henry?
Yeah, I'll propose a simple reinstatement order to Mr. McLean tomorrow. Just so that we can make sure that we're on the same page and then
Okay.
get it to the court if that.
Okay. That's fine. That's perfectly fine. Okay.
Okay. Ready to
All right.
vote?
Thank you. Thank you, gentlemen. Now I've got like 5, 6, 7 cases, but
Thank you, Your Honor.
you're welcome. Take
Good day.
care.
Bye.
Okay. Um, Miss, I need a break for like 3 minutes. Give me 1 second. I'll be right back.
Sure.
Okay. All right, let me get my list. Now, how do we want to proceed? I have my list.
I think we can go, if you would like, we have, I believe the first four cases are uncontested, 1 through
Okay.
4.
Okay.
And
Four is going to be dismissed by me
okay, so 1 through 3 are.
or
uncontested.
adjourned, I guess.
Okay, so Ms. Clifton, you can start calling and then we'll slow down once we get past 4.
Okay, case number 24005-354CH. This is 18935 Pinehurst Street.
Council appearances for the record.
Thank you. Ebony Jamison on the behalf of the Detroit Land Bank Authority, P75856. This is the date and time set for this hearing for, I'm sorry, this is the date and time set for this hearing for expedited quiet title and foreclosure action. The proper service requirements have been met and the parties have failed to appear. This particular property is a property that the land bank received after tax foreclosure, and it has been previously quieted title. But after we had completed and gotten our quiet title judgment, a party added themselves into title fraudulently, and therefore we are here before you again to clear that interest. So I'm before you today to ask for a judgment of quiet title. The time that this matter was scheduled for was 3 p.m. and no parties have appeared.
Okay, based on the representations placed on the record and the person apparently fraudulently interjecting himself into the title, the court is satisfied and the court will grant quiet title as it relates to 19835 Pinehurst, Detroit 48221.
Thank you, Your Honor.
Thank you.
Case number 2401405-3CH with regard to 17216 Westphalia.
Council appearance.
Kimberly Anderson, P79691, appearing on behalf of plaintiff, Detroit Land Bank Authority. This is a date and time set for motion for entry of default judgment to quiet title as to parcel 2017216 Westphalia. This property is a reconveyance property. It was sold to a Jamar Barrett. Mr. Barrett passed away prior to him completing the rehab on the property. His family is interested in obtaining interest in the property. There is a family member that lives there. This property is going to go through our buyback program. The family has been advised we can't make any guarantees. They do have to qualify, but I just wanted to make a record that the land bank is going to try to work with the family, but we are asking for quiet title in favor of the Detroit Land Bank.
Okay, and they understand that they have to do certain things in order to get this property back.
Correct, Your Honor.
Okay, based on the representations placed on the record, the court is satisfied and the court will grant quiet title as it relates to 17216 Westphalia, Detroit 48205, noting that the family will work with the land bank to attempt to buy back the property and comply with whatever is asked of them. Okay, thank you.
Case number 25007-801CH. This is with regard to 4720 Holcomb and 423 Marlboro.
Council appearance.
Thank you, Your Honor. Ebony Jamison on the behalf of the Detroit Land Bank Authority, P75856. As in regarding to parcel 124720 Holcomb, a party came forward stating that he was a relative of the party who had been who we had received a judgment against via nuisance abatement. The party, the individual stated that he was going to have a estate opened in order to go through probate to formalize his interest in the property. I have not seen that an estate has been opened. I've checked the Wayne County probate courts, and I've also checked the Oakland County probate courts. And therefore, I am before you, and I have not heard from the party as of this time. I'm before you today to ask for a judgment of quiet title as to 4720 Holcomb. The proper service requirements have been met, and the party has failed to appear. And as to 423 Marlboro, this property, we were in discussions. This is also a property that was acquired via nuisance abatement. We were in discussion with a attorney who is working on this matter. The attorney was supposed to return a set-aside document agreeing to rehab the property. He has failed to do so. I believe it has been over 4 months since the set-aside was sent out, and we have not received a signed document back, and we have not received any further communication from that attorney. So we are also asking for a judgment of quiet title as to that property. Again, the proper service requirements have been met and the parties failed to appear. The time scheduled for this matter was scheduled at 3 p.m. It is now 5:30.
Okay, based on the representations placed on the record as it relates to 4720 Holcomb, Detroit 4821, where the parties indicated they would open up a state and failed to do so, and a significant period of time has elapsed, the court is satisfied, the court will enter default judgment quieting title. As it relates to 423 Marlborough Street, as the attorney has failed to provide the requisite information that was requested of him, and the proper notice and service requirements haven't been met, and the attorney has failed to appear and has failed to further litigate this matter, the court is satisfied and the court will enter default judgment quieting title as it relates to 423 Marlborough, Detroit 48215.
Thank you, Your Honor.
Thank you. Ms. Clifton.
Okay, numbers 4 and 5 have been adjourned, so we're going
I thought Mr. Thomas was going to dismiss 4. Are you dismissing or
Ad-
you adjourn?
Adjourn it for now and then hopefully dismiss
Okay.
it very
Okay,
soon.
thank you. I'm sorry. Go ahead, Ms. Clifton.
case number 2501128CH with regard to 13184 Compass.
Counsel appears for the record.
Kimberly Anderson appearing on behalf of Detroit Land Bank Authority. I believe April Newton was in the waiting room.
April Newton. I don't see her. Miss Clifton, do you see it? Do you all see? You all are calls. Check on
I
the
do.
participant.
There's an iPhone that is unaccounted for. I'm not sure if that's her.
I think Miss Clifton had okay.
I tried, they didn't answer.
Well, this is the last time and we'll have to go on then. Can the party on the iPhone please identify themselves?
This is Attorney David Jones. I apologize, Judge. I had to leave the office to go pick up my daughter, take her to basketball practice.
Which case are you on?
He's on one of mine, Your Honor.
1724 Euclid.
Had you had a conversation with Mr. Thomas?
I have.
Okay, we'll place you back in the waiting room. We'll be right back with you. So, Miss Anderson, it doesn't look like we have. What's your pleasure with regard?
I'd like to proceed. I think she's aware of where we were going with this.
Okay.
This is a date and time set for motion for entry of default judgment to quiet title. This is a reconveyance parcel. I'm sorry. The Detroit Land Bank sold this parcel to a gentleman, I believe his name was Frank Jones, if I'm not mistaken. Mr. Jones also passed away. Unfortunately, Mr. Jones transferred this party to April Newton's child, put in the transferred property into a child's name, which we know that can't be done. April Newton is living in the property. So again, we are going to attempt to work with her in our buyback program. She is aware that we can't make any guarantees. However, we do have to have clear title before a property can go through our buyback program. So we're asking that quiet title be granted in favor of the Detroit Land Bank.
Okay, based on the representations placed on the record, the court is satisfied and the court will enter default judgment quieting title in the land bank as it relates to 19310 Gallagher, Detroit, Michigan 48234.
Thank you, Your Honor.
Thank you.
So number 7, Attorney Rock was here on that and it was adjourned, but we're gonna still do the Cooper?
Correct. Yes.
Okay.
Okay, are we adjourning 6? Did we? That was what
that was Compass that you just did?
That was case 6 that we just did on Compass.
Okay, my bad. Well, then I need to correct myself because I gave the address and there's an error on my part. I gave the Gallagher address as to 250-111-128CH. It's the address, which according to the default judgment quieting title is 13184 Compass, Detroit, Michigan 48227.
If I might correct the name of the reconveyed party, Your Honor, that party was Frank Wolf. I said it was Frank Jones. His name was Frank Wolf, just so that the record is clear.
Oh, and that is as to the Compass property, correct?
Correct.
Okay, thank you. Thank you. So I think we both stand corrected now.
Yes.
Okay. So I am now as to property case number 7, you're adjourning Mendota, right?
Correct.
And we're gonna get ready to do Cooper.
Yes, and I believe Mr. Wren is present.
Mr. Panlaki? So,
Yes.
okay.
Oh, I can't see.
This is case number 25016-123CH with regard to 5360 Cooper.
Council appearance for the record.
Kimberly Anderson, P 79691, appearing on behalf of plaintiff Detroit Land Bank Authority.
And sir, can you state your name, please?
It's Ren Penlaki.
Okay, thank you. Ms. Anderson?
Your Honor, the land bank sold the property on Cooper to Mr. Penlaki June 2023. Mr. Penlaki was very non-communicative, provided insufficient evidence of his progress towards compliance, did not follow up at all during the term of his ownership. The property was taken back via reconveyance deed, April 2025. This matter was originally scheduled for November 19th, where we appeared before the court in person. Mr. Panlaki was present. Mr. Panlaki was told that he had to follow up with our compliance team to see if he could be reconsidered for ownership, and then the hearing would be delayed to today. Mr. Panlaki spoke with our compliance team on November 28th. He was advised as to what he needed to do to be reconsidered for ownership. He was told that he needed to provide pictures, proof of funds to bring the property into repair, and he has failed to do that. We're asking that quiet title be granted in favor of Detroit Land Bank. I do have photos if the court would like to see what the property looks like. Our position is that Mr. Panlaki lives out of state and he has failed to care for this property on Cooper and have left the neighbors to deal with the nuisance.
Okay. Just quickly show me a couple and then I'll move on. Just
Okay.
quickly.
Here is what the property is the court able to see?
Yes.
Okay, here's what the property looks like. I do believe that since the last hearing, he did put some boards up on the property.
Put on the boards, I repainted it, and then I was they told me to stop the work. I didn't neglect. I paid contractors. I put in some money funded. Every time I visit you folks, it costs me $500 to $700. And I'm not the actions and reflect responsibility, not abandoning, believing I'm protecting it from the damage and not to realize the prior approval. That's why I put up those stuff and I funded when I was there that month. I saved up money, ready to comply fully. I will strictly follow the court instruction. I want to resolve legally, respectfully, and under the court's guidance. I do not want to conflict. I just want to do the compliance and fairness.
But Mr. Penlaki, let me just say
Yes, ma'am.
something. What had happened was you were supposed to provide them with the agency with your proof of funds and what else was it, Miss Anderson?
Proof of funds, a construction template, a rehab cost template. He was given an outline of the 4 or 5 things that he needed to provide in a due date, and he failed to do so.
Yes, I do. I do receive that, but I was a misunderstanding of that of those projects. When I left the court, I was granted by you. I really appreciate that. I got excited, and then I told my guys go ahead and start doing. And upon prior spending some money, and it got stopped. And I got all the lists, and I wasn't aware of those funding, and I can send out some money immediately to expedite this process.
It's not the money, sir.
Yes.
It's just presenting. All you had to do is present the plan, present the proof that you had the funds, and you didn't come forward.
Yeah,
That's all.
And this property's been sitting for 2.5 years when you were supposed to fix it up within 6 months.
I'm really apologize on that, and I had some guys that working on it, no abandonment. It was clean on the front porch, remove all of the debris, and it got actually repainted on the front and until they told us to stop. And I didn't understand that part right there. I
That
just
was
got
the main,
over
that was the main part. All, you know,
this
at the time,
on
they didn't want you to physically do anything. They wanted you to produce the plan and produce the fact that you had the funds to substantiate. Is that right, Ms. Anderson?
That's 100% correct, Your Honor. And you said it, and I also said it in the court hearing that the process in order to get the property back is you have to be vetted for reconsideration to make sure that you have the plan in place, the contractors in place, and the funding to do so. And at this point, our compliance team has denied Mr. Penlocky's request to be reconsidered.
Right. And based on the fact that the court, you know, when you get to me, this is a last ditch effort and they're prepared to go forward, but the court gave you an opportunity. And when the court speaks, you're supposed to comply with what I say, not what you want to do. And it appears that you didn't. And what I had really offered to you was in a much easier place than where you went. So unfortunately, the court is going to have to deny your request to have an extension because you've been given an ample extension, and the court's going to enter the default judgment in the land
um
bank.
Thank you,
I
Your Honor.
already put a lot of investment to it, Your Honor. Like I
But
said,
sir, that's not the point. You have to follow the law. The law is that you have to go through the land bank. All you had to do is present the paperwork. Miss Anderson said that there was no communicate directly with her office or the land bank office in terms of that. That's what we asked,
I,
and I don't know why you didn't follow and
I
didn't understand it, but I can't go any further, sir. People have to be compliant with what is asked of them of the court, and you didn't. So
uh,
this so
uh,
this time I'm entering the order of default judgment.
can you
Thank you,
please?
sir. Thank you so
Um,
much.
I understand that, ma'am. I had my not trying to abandon any of this. I'm here. I went to Detroit, communicating through it. It's just I just don't know all those process, the numbers to call to get it all equated to all of the requests.
We tried to give it to you, and the thing is when people are out of town, that happens because you're not in town to follow up. So unfortunately, we have to move on, and I thank you so very much for your time, sir. That concludes this hearing. Thank you very much.
Oh, so what would be my next option right now? And I would like to please get another approach to this. I don't want to. It
Miss,
was
I
just
don't
too
know.
much for me, Your Honor.
I understand, but
Yeah.
Ms. Anderson, is there any other recourse at this juncture?
Please, Miss Anderson. I mean, this is. I'll do. I'll
No,
even
no, hold
drive
on.
out
Well,
Hold
there
on.
till
Hold on,
next
sir. Hold on, sir.
next week, today,
the only
tomorrow.
other approach would be taken in consideration that the court has ruled and granted the land banks its relief. I can attempt to put Mr. Penlocky back in touch with the compliance team to see if they will give him another opportunity. But typically, once they have denied you for failure to meet the deadlines, they will not reconsider. But that's all I can do at this point.
So
Yes, yes, thank
Miss Anderson, will you send him an email or what?
He can give me a call tomorrow, or he would just actually just reach back out to the same gentleman that you spoke with, Juan, and our compliance team.
Oh, I would like to request that all of all of the needs to be filled and the phone numbers, so I could start one by one
Well, if you want to just
to
give me a
fund
call
those.
tomorrow, I can possibly help you with that.
Miss
My apology for all of this mess. It's just I love Detroit. I told everybody, my family, I have a home there, and it's not like oh, I'm just abandoning it. I didn't show up there, but I appreciate this one last of a push of a
Well, so you're clear, the
couple of
court
help.
has
I
granted
have,
the land bank's relief,
Yes, ma'am.
but we'll see if there's anything else that we can do.
Yes, please. Work
please
with me,
call.
Miss K.
Okay, call Miss Anderson tomorrow. Thank you very much.
Thank you, ma'am. Appreciate
Thank
it.
you.
All
You're
right.
welcome.
Have a
Bye-bye.
good night.
You too.
Your Honor, I'm not sure, but maybe we can go to the cases 9, 10, 11, 12, and 13 that are uncontested and then come back to
Okay.
the properties that have parties.
Okay, that sounds great.
So
Okay,
I'm
Miss
going to
Clifton.
9, you say?
Yes.
9, okay. That is case number 250175999CH. This is with regard to parcels 1, 3 through 6, 8 through 14, and 16 through 17.
Council appearance.
Kimberly Anderson appearing on behalf of Detroit Land Bank Authority. This is a date and time set for motion for entry of default judgment to quiet title. All of the interested parties have been properly served in accordance with the Land Bank statute and have failed to appear. This matter was scheduled for 3 o'clock and is now 5:44. This would be as to parcels 1, 3, 5, 6, 9, 11, and 17.
5, 6, 9, 11, and 17.
11 through 17.
Oh, 11 through 17?
11 through 17, because there is someone here as to parcel 4, and parcel 10 was adjourned, and parcel 7 was adjourned.
Did we say 8?
Yes, 8 as well.
8 is adjourned, or we're going forward on 8?
We're moving forward.
Okay, so we're moving forward on 4, 8.
On 1,
Okay, I'm sorry. Go ahead.
1, 3,
Oh,
5, 6, 8, 9, and 11 through 17.
we're going forward on those?
Yes,
Okay, all right.
thank you.
So those are the ones that you're asking, wait.
Those
Would
are
you-
uncontested, so we're asking for judgment on those ones that I just named.
Okay, so just place the notice requirements on the record and we'll go forward. The servicing.
Thank you. So all of the interested parties in this case have been properly served in accordance with the Land Bank statute and have failed to appear or reply. This matter was scheduled for 3 o'clock. It's now 5:46. So we ask that quiet title be granted in favor of Detroit Land Bank.
Okay, based on the representations placed on the record, the court is satisfied the court will enter a default judgment requiring title on the land bank as it relates to parcels, and correct me if I'm wrong, 1, 3, 4, 5, 6, 8, 9, 11, 12, 13, 14, 16, and 17?
That's correct. Did you say parcel 1, Your Honor?
Yes, 1 and 3, yes.
That's correct. Thank you.
Okay, the court will enter default judgment requiring title on the land bank as it relates to those parcels.
Thanks.
Thank you.
Okay, and we're not bringing anyone in right now. Where would you like for me to go?
Number 10, I believe, is uncontested as well. Am I correct, Andrew?
Number 10 is uncontested.
So that is case number 25017-208 CH 14189 Burt Road.
Council appearance.
Good afternoon, Your Honor. My name is Andrew Thomas, P67948. I'm an attorney for the Detroit Land Bank. Today is the time and date set for the Land Bank's petition for a quiet title judgment under the Land Bank Fast Track Act. The Land Bank followed the act's notice. The Liz Pendens was recorded, certified mail, occupant mail, and the property was posted. The compliance with the act's requirements entitled the Land Bank to a quiet title judgment is such that Detroit Land Bank requests a quiet title judgment in relation to 14189 Burt Road.
Based on the representations placed on the record, the court is satisfied. Court will enter default judgment quality title land bank as it relates to 14189 Burt Road, Detroit, Michigan, 48223.
Thank you very much.
Thank you. It looks like we got-
11?
Yes.
11 has some folks here. Number 12 is going to be a dismissal. And somebody is here on that. His name was Clement Grimes.
Okay.
Maybe we could call him in just to let him know he can go.
Okay, well, let's go see what else is going on. I know we're going to dismiss 12. There is somebody here.
There's a ton of people here on 12, and then there's on number 13, I believe that's all good. That one can be a
You can do that.
default in total, yes.
Okay, Ms. Cook, we'll call 13.
25018-909 CH with regard to parcels 1 through 5.
Council appearance.
Good afternoon, Your Honor. Today is the time and date set. My name is Andrew Thomas. I'm an attorney for the Detroit Land Bank, P67948. Today is the time and date set for the Land Bank's petition for a judgment for quiet title pursuant to the Land Bank Fast Track Act. The Land Bank followed the Act's notice requirements. The compliance with the Act's notice requirements entitled the Land Bank to a quiet title judgment. As such, the Detroit Land Bank requests quiet title as it relates to 1514 Hazelwood, 2226 Hazelwood, 2059 Pingree, 1674 Taylor, 1723 Taylor.
Okay, based on the representations placed on the record, the court is satisfied and the court will enter default judgment quieting title as it relates to those properties just articulated by Mr. Thomas.
Thank you very much, Your Honor.
Do the shortcut for that one. Okay, now on 11, are there any parcels that we can go forward on before we bring these people in? Because I see we have 2 people, but there's 17 property. I know as to 12 we're going to dismiss.
12, we're going to dismiss. 7 has somebody here, but the rest we could
Call.
call.
Okay. All right, Ms. Clifton, number 11.
This is case number 250177955CH parcels 1 through 17.
Council appearance for the record.
My name is Andrew Thomas. I'm an attorney for the Detroit Land Bank. Today is the time and date set for the Detroit Land Bank's petition for a judgment of quiet title under the Land Bank Fast Track Act. The Land Bank followed the Act's notice requirements. Compliance with those requirements entitled the Detroit Land Bank to a quiet title judgment. As such, the Detroit Land Bank requests a quiet title judgment as it relates to 802 Anderson, 5073 Beaconsfield, 9681 Brockton, 3803 Bushy, 14369 Coley, 12312 Evanston, 15639 Fordham, 4027 Garland, 7576 Geese, 13118 Myers, 13010 Promenade, 13625 Tacoma, 2930 Tyler, 4137 Van Dyke, 15831 Wabash.
Okay, based on the representations placed on the record, the court will enter default judgment quieting title as to the properties outlined by Mr. Thomas. I'm sorry.
Your Honor, actually, the Van Dyke, there is someone here on. I'm sorry.
The number 16?
Number 16.
Okay, so we'll exclude 4137 Van Dyke, but the court
Thank
will
you.
enter default judgment quieting title on the land bank into all of those properties. And we have, the court will enter a dismissal as it relates to 5217 Mount Elliott. And I think we have someone here on 1271 Flanders and 4137 Van Dyke, correct?
And someone's here on that Mount Elliott that we should
Okay.
notify to release.
Okay, so we'll bring in the gentleman, Miss Clifton, on the 5217 Mount Elliott.
That was that Clement Grimes.
I think he's gone. I don't see him. No, he's there. He's there. Okay. Mr. Grimes? Mr. Grimes? As well, we'll put it on the record again. Mr. Grimes, as it relates to 5217 Mount Elliott, the court is dismissing the petition.
Okay.
And I think you've had a conversation with Mr. Thomas, correct?
Yes, ma'am.
Okay, thank you very much. That concludes
you.
your hearing.
Thank you very much, sir.
Thank you. Okay, and you said we have somebody 4137 Van Dyke. Miss Williams, Miss Clifton?
Correct.
Miss Williams? Miss Williams? Miss Francine Williams?
Yes, it is.
Okay. This is as it relates to 4137 Van Dyke. Ma'am, would you state your name, please?
Yes, it's Francine Williams.
Thank you. Mr. Thomas? Yes.
Your Honor, I've had the privilege of talking to Miss Williams, and I explained to her that a nuisance and abatement judgment had entered against the property on 6/3/2025. It was case 240154447-CH. It was recorded on 7/23/2025 at Liber 59678, page 583. I explained to her that if she wants to continue to own this property, she can ask the attorney, the NAP attorney, who happens to be me, to set that judgment aside. There are some costs associated with it, and she would have to sign an agreement to abate the nuisances related to the house. She didn't want to do that and wanted to talk to you.
Ms. Williams?
Yes.
I don't know. In terms of the thing is if there's problems on the property has to be rectified in some sense. You have to comply, and that's just, they have people that come out, the attorneys that deal with these cases. So when you get to this point, there are costs associated with it, and you do have to sign the agreement if you want to retain the property. Otherwise, I'm going to go forward with the default judgment.
Well, at this point, I wanted to stick with what my motion says because my husband was not notified of that. And he does have marital interest into his property as well.
Well, the thing is it your property? Because I can't talk to you if you're not the person listed. Are you listed?
I'm listed. My husband is not listed, but that doesn't make any difference
Yes, it
legally.
does. It does legally. Yes, it does. Whoever's listed on the property, that they have the responsibility. The ultimate responsibility is yours. And if you don't want to sign the agreement, then the land bank can take the property back. But what they've asked you to do is to sign an agreement. They're willing to work with you. You have to sign the agreement. You have to pay whatever it costs, because there's always costs involved, and comply with whatever they ask. That's the only thing. If your husband's not listed, then he doesn't have a legal interest. You might say he has an interest, but if he's not legally on it, he doesn't have a legal interest.
Well, he has a marital interest.
Understood, but that
money.
is not, no. If he's
No.
not listed on it, I'm just telling you. I'm telling you how the law applies, ma'am. So the question is, do you want, we can go
What are
for,
you asking me to do?
well, the question is, if you want to retain the property, Mr. Thomas, I think, gave you the information. Did you not, Mr. Thomas?
It would, we'd have to ring up a bill. It's usually between $1,000 and $2,000 in the different costs, getting the two cases through. But she'd do that. She'd sign an agreement saying she's gonna abate the nuisance.
What is it?
Well, what
Okay,
is
so-
the nuisance? I
okay.
never was aware or told what the nuisance was. In that notice that I never got notice of what you needed to be done.
Okay, I think what Mr. Thomas, what we're gonna do is we'll adjourn this, give Ms. Williams an opportunity. Either, I don't know who in your office you want her to speak with.
She could speak. I'm now the attorney that's handling that was assigned that other case too.
Okay, so Ms.
The-
Ms. Williams, Ms. Williams,
Yes.
do you have Mr. Thomas's information to contact him?
No, can I get it?
Yes, Ms. Williams, my direct dial at the desk, telephone number is 313 261 9930.
Okay, I have it.
Okay,
I
I would
All right,
advise.
ma'am. Why don't we plan on you giving me a call tomorrow morning, after 9 in the morning, but before lunch, okay?
Okay.
And we're gonna put this over, Mr. Thomas, to when?
Let's push it out till March 18th. That way,
Okay, is that March 18th via Zoom?
yes.
Miss Williams, you're not gonna get any more notice. March 18th, 3 o'clock. March 18th, 3 o'clock. But still, we need you to call Mr. Thomas tomorrow morning before noon, after 9 and before noon. Okay?
Okay, I just wrote that down.
Okay, so you call Mr. Thomas after 9 and before noon, and then your next hearing on Zoom is March 18th at 3 o'clock. Okay, thank
Okay.
you. That concludes this hearing. Thank you very much.
Thank you very
Okay.
much, Ms. Williams.
All right.
Okay. Now we're finished with 11, right?
No, we have
7?
12715 Flanders.
2. I don't see the 12751. Who's on that?
12715 Flanders.
Oh, Miss Clifton's on it, I guess. Okay, Miss Stanford.
Yes.
Okay, this is as to 12715 Flanders. Would you state your name, please?
Yes. Kainika Stanford.
Okay, thank you. Mr. Thomas?
My name is Andrew Thomas. I'm an attorney for the Detroit Land Bank Authority. This matter comes to us by way of NAP, a nuisance and abatement program default judgment. The judgment was entered on 3/13/2025. It relates to case 23-006991-CH. That judgment was recorded with the Wayne County Register of Deeds on 5/12/2025 at Liber 59542, page 931. If in this case, if Miss Flanders, wants to enter into an agreement, she would have, I don't know who the attorney is, that she'd contact. But there's the two of us, myself and Sheila, so it's probably Sheila. She could, once all of this is done, she could request that that NAP judgment be set aside, but barring that, the title is in the Detroit Land Bank's hands. So at this point, we're asking for a default, or excuse me, we're asking for a judgment of quiet title.
Okay, so I don't know if you understand that, Ms. Stanford, but what has to happen is if you're planning to go forward and correct whatever issues are out there, you need to contact Ms. Bellew and Mr. Thomas. Well, if you don't have that number, do you have the number for the land?
If she's interested in doing that, she can call me and I'll try to figure out who it is. It's 31, my telephone number, ma'am, is 313-261-9930.
Okay, and if you're interested in making the corrections to the property, are you, ma'am?
Yes.
Okay, and then you call Mr. Thomas. Mr. Thomas will put you in touch with whomever, but we'll put this over to March the 18th at 3 o'clock. But you need to reach out to Mr. Thomas tomorrow after 9 and before noon.
After 9 or before noon. Okay, thank you.
And he gave you have the number, correct?
Yes.
Okay, all right. Thank you very much. That concludes.
Thank you.
the hearing. Thank you. Okay. Ms. Clifton, where are we going next?
I don't know, Your Honor.
Oh, we
If you could
finished.
go
We
to
fin-
9, I believe there's somebody on Kim's case.
9, is it?
Yeah, so there's someone here for 1400 Beatrice.
14.
I think Douglas O'Neill.
Okay, Mrs. Clifton, call the case when you're
So
ready.
we called it. This is just as to which parcel?
I'm sorry, parcel number 1400 Beatrice.
Okay, so again, recalling 250175599 with regard to parcel 4.
Council parents.
Kimberly Anderson appearing on behalf of Detroit Land Bank Authority.
Sir, you need to unmute yourself, turn on your camera and state your name.
Yeah. Douglas O'Neill.
How do you
Ms. Anderson.
Thank you, Your Honor. Your Honor, the land bank found this property to be vacant, abandoned, and open and a nuisance. This court entered a default judgment back in April 2025. Title was transferred over to the Detroit Land Bank. At that time, we found the owner of the property to be the estate of Donald Evans, and notice was sent to the estate of Donald Evans as well as relatives. I received a phone call from Mr. O'Neill claiming that he has purchased the property from Mr. Evans prior to his death. I have no record of that. Moreover, the property is in horrible shape. And so it's the land bank's position that we are requesting quiet title. I also spoke with Mr. Evans' wife, who was he was married to at his time of death, and she too is not aware of any transfer that took place to Mr. O'Neill.
Okay, so
But regardless, the property is entitled by the land bank at this point.
right, and we don't have any evidence that Mr. O'Neill owns that it still was titled in the wife, and she wasn't prepared to do anything.
Correct.
So that being said, the court's prepared to enter default judgment. Mr. O'Neill, I'll give you a minute to state whatever your position is, but we don't have anything that supports that the property was deeded to you.
Well, I was in the area. I live out in Southwest Detroit, and I'm interested in the property, and I seen someone working on it, and I stopped and I talked to her, and I said I was interested in the property, and so we talked, and we came up. She said she owned the property, and she came up with the deed, and we signed it, and that was that. And I was dealing with cancer at the time, and I never got the deed registered. Never got it registered because I was going through what I was going through. But
Who is this she that you're referring to?
her name is Paige Bondi.
But apparently I don't think she owned it. She fraudulently conveyed that property to you. She had no interest. Maybe she found out Mr. Evans died and then was trying to do a fast one, but that woman had no interest in the property. So unfortunately she had nothing she could convey to you because she didn't rightfully own it, Mr. O'Neill. So and it's nothing that I can do about that. But she wasn't a rightful heir or owner of that property. So I don't know what she was doing, working on the house or whatever, but she was improperly there. So unfortunately, you don't have any standing in this matter, and she defrauded you because she didn't have any interest in the property. So that being said, the court's going to go forward and enter a default judgment because the wife said that she was the only person.
Oh, can he talk to her and maybe get it from her?
She doesn't own it anymore. It's going back to the land bank. If you were interested in the land, Miss Anderson, I don't know what the course, I'm not going to step into you all's lane.
Yeah, so based on the condition of the property, I don't even know what our plan is. I do know that the garage had to be torn down because it was leaning over. So we have spent money on that. So there will be a lien on the property at this point to cover the demolition costs. And I know that the house itself has had a fire. So at this time, I don't even know what our plan will be, if any, at this time.
Well, I mean, the property is still standing. I have bought a few homes from the land bank, even worse condition than that one.
Yeah, well, right now, sorry to cut you off, but it's late. And so at this point, I just don't know, we're asking for our judgment to move forward. I would say just continue to check our website, and if it's available for sale, it will be on there.
Okay.
Can I ask a question?
Quickly, I have cases, ma'am, and it's late.
Why? Because I'm not, if I'm not mistaken, is in demolition status, even though I have had it able to take it off of demolition status. How would that work? Would they still put it on the up to buy?
I don't know. We don't know. And as Ms. Anderson said, she can't speak specifically to what's going to happen with the property. So you just have to check the land bank and see if it, periodically and see if it comes up because she doesn't know. She can't speak. She's an attorney. She's not the demolition expert. So as she indicated, the best bet will be to continue to check the land bank and see if the property is listed.
Can we get in contact with, do she know that department? A contact person?
You can give me a call tomorrow and I can try to put you in touch, but they're not going to be able to really answer any questions until at least another couple months. We have to go through this process first, and there's a process. So just give me a call and I can try to at least put you in our system.
Okay.
All right.
Thank you very much.
Well, thank you.
Okay, based on the representation placed on the record, the court would enter a default judgment quantity title as it relates to 1400 Beatrice, Detroit 48217. That was correct, right?
Yeah, 1400 Beatrice. Yes,
yes.
sure.
Okay. All right. Thank you very much.
There's someone named Tanweer Ahmed, no, on this case as well.
Oh, yes. On V.
On which one?
So that wasn't even, it's not even up today.
What?
It's parcel 15 on this same case.
If it's not up, we don't have.
I tried to tell him, I went in the breakout room ahead of time to let him know it wasn't being heard today. And
Because you have it adjourned, Miss Anderson?
yes,
Okay,
Your Honor.
fine, thank you.
So I'm not bringing him in.
No, you can put it,
Okay.
put it in the chat that it's, what, do we know the adjourn date, Miss Anderson?
We can do March 18th.
Okay, put, Miss Clifton, you can put in the chat that Mr. Ahmed's, is adjourned to March 18th.
Okay, and I have persons here on case number 12 and also number 8. I have attorneys on 12. And
Yeah, it's 2 attorneys.
Which
Whose
one am I
case is
going?
that? Let's do 8 first.
Okay.
Who's 8? Which
That's my case. Carla Brandon is here.
Okay.
On what property?
Parcel 14310 Cortland.
Which case is that?
I'm sorry, case number 8.
Oh, we still, oh, 8.
It's on the first page.
Okay, thank you.
It's case number 250157666CH4310 Cortland.
Ma'am, would you turn on your camera, please, and unmute yourself? Attorney Anderson, state your appearance for the record.
Kimberly Anderson, P79691, appearing on behalf of Detroit Land Bank Authority.
Okay, and Ms. Brandon, again, unmute yourself, turn on your camera and state your name for the record.
Carla Brandon.
Thank you. Counsel?
Your Honor, the Detroit Land Bank has deemed this property vacant, nuisance, and the city has determined that it is in need of demolition. It looks like this court entered a default judgment back in August of 2023, and the property has since been demolished because of its disrepair. Ms. Brandon was sent notice of that hearing that occurred in August of 2023. So it is the Land Bank's position that we're asking for quiet title.
Ms. Brandon, anything you need to add?
No, I really didn't receive anything. The tree fell on my house. Yeah, Detroit had a storm. I tried to get some of everybody to fix it. It took the side of the house, and yes, the tree was there. So I tried to get different people because FEMA and all of them was still giving out money. I went for the city to try to get help from everybody, but nobody was helping. Of course, we had to move because we couldn't stay there. We didn't even have electricity. Now, we wasn't coming back. At first, we was coming back and forth to Cortland and checking on Cortland because I still had a vehicle there and stuff was still there. But of course, when nobody was helping, we had to move. But no one was contacting me. The only time I got paper was after they sent it to my address here on not Cortland, but they sent it to here on 1255 Elijah McCoy. So that's how I knew after the fact that the land bank was having court was after. Just like I got after I think in January of December of last year or something, they gave it to the city. And then I got something to appear to court, like I think it was for November. And I came November and they told me no, wait until December. And then December, when I talked to her, she said that they'll see about 6 months so I can see about if I can get this house together. But now I got here in January and I didn't know if they was tearing it down or what they're going to do to it because I hadn't been back because this transportation problems going back and forth.
So, Your Honor, Ms. Brandon did appear at the November 19th hearing. I didn't realize what property that she was here in regards to. She called, then it was adjourned to December 17th. We spoke that morning. I told her I would talk with our nuisance and abatement team to see if there was anything that we can do. And I adjourned it to today, and that's why we're here today. And I do have pictures of what the property looked like prior to demolition, if the court would like to see it. I'm not even sure what Miss Brandon is wanting at this point. The cost of demolition looks to be about $25,000. So I don't know if she's looking to buy the lot, which will come with the $25,000 lien. So I'm not even sure what Miss Brandon is wanting at this point.
What is it that you're
So
seeking?
oh, well, I can ask a question. With the $25 lien, can it be built on it, like property built on it, or it's not gonna be deemed for nothing to be built on Cortland?
I honestly can't speak to that from an attorney standpoint. What I do know is typically the guidelines have changed as it pertains to building on residential lots, and I don't know if that property meets those codes. So I have no idea.
So, Ms. Anderson, at this time we were just here to enter the default judgment. Once we enter default judgment, Ms. Cortland can contact the land bank and make a determination whether it's worth her while to pay what is outstanding on it as a result of the demolition, correct?
Yes, if we were, I'm not even guaranteeing that we're going to sell it, but if we were to sell it, I just wanted her to be clear that it would come with these liens and all of the taxes and all of the things. So I just wanted to make sure that that was clear. I don't know for sure if we're going to sell it, but if we do, that would be the consequence.
Okay.
And she would have to make that decision. And again, just continue to check our website if it is available for sale. Typically, we will sell a vacant lots to the neighbors next door first, and then it will go out to the public. So she would just have to check with us and kind of see where we are.
Okay, so
So, quick question, would a house be 2,500 for the neighbor next door or 2,500 for me?
It wouldn't be 2,500. I said 25,000.
25,000.
25,000, yeah. And I'm not sure how that works. It depends on the program in which the demolition cost came from. So it just depends.
okay, all right, thank you. At this time, the court's going to enter the default judgment quieting title. And like I said, Ms. Brandon, if you want to express an interest, I'd strongly urge you to call Ms. Anderson tomorrow between 9 and 12, and she can give you some additional information if it's available.
Thank you, Your Honor.
Thank you.
Okay.
Are we done with that case?
Yes, we are. That concludes
Okay.
this hearing.
We should be on number 12 now.
Ms. Brandon, do you need me to remove you?
Yes.
Thank you. All right, so. And I should bring the attorneys in now?
I guess, yeah, because we said did you put something in the chat for Mr.?
I will, I have to.
Okay, thank you.
I think this is Mr. Jones. Well, this is case number 250180993CH with regard to parcels 1 through 8.
Wait, council appearances for the record?
My name is Andrew Thomas. I'm an attorney, P67948.
Yes, everyone. Good evening, everyone. Shiraz Khan here on behalf of interested party Eric Herrera. This looks like parcel 1, 4, and 5. 1814 Lawndale is 4, 1818 Lawndale is 5, 8389 Gardner is 1.
Okay. Which case is this, Mr. Tom?
This is docket 12.
Well, okay. And 8. So that was 4, 5, and 6, was it?
1, 4, and 5.
I'm
One,
here on
four.
1, 4, and 5. Yeah.
Okay, all right. Mr. Thomas, what's your pleasure?
Let's start with 1.
Okay.
So, Mr. Khan did file a response. However, his response is that his client got duped into buying these. He admits his client purchased a fraudulent deed. The Detroit Land Bank got its interest as a result of a tax foreclosure that happened in 2019. The Wayne County Treasurer conveyed it to the Detroit Land Bank in 2019. And then in 2025, it's alleged that his client purchased it from a Ramirez Juan Domenico, who didn't hold title to it.
Okay, so Mr. Khan, since this is a fraudulent conveyance, what do you expect us to do?
Well, what I'm asking for is, so first of all, Your Honor, just a couple things on this. For 1818 and 1814, we did file a lawsuit. I believe it was filed a day prior to when counsel filed his petition. And I'm looking at the statute. It doesn't really, it's sure, although it talks about legal titles, says anybody who has an interest can make this claim. I'm asking for a hearing where my client can come in and testify. And he's made improvements to these properties. He spent about, I think, $6 or $7 grand on the properties to add a fence. He's been paying some taxes on it as well. And I think that when it comes to the issues involving the first matter that's not before the court today with the fraud, we're still like, they haven't responded yet. She hasn't filed a response yet. So I don't know if the response is going to be, because the representation that I understood is that the payments that he made to her, she was working with the land bank. So I don't know exactly where she stands on that. So
Where
I'm
the
asking.
she is that's if it's something fraudulent, how do you expect us to litigate it? That's not, that's a criminal matter. That's a criminal matter.
Well,
Who is
that's
this
why.
she? Who are you talking about, this she? Who is she?
This is the individual that we sued, and we'd included that in our brief. This is Avelia Gonzalez and La Riverita Services as well.
Mr. Thomas.
And
they're not in the title chain. They're not working with the Detroit Land Bank Authority. They don't hold title, and either does this attorney or his client. The Detroit Land Bank holds title. They trespassed. That's the beginning and end of the case.
Right. There's no standing here because it was fraudulent. All those fraudulent activities has no bearing on this case. So the court's going to go forward and enter the default judgment acquiring title. You have your lawsuit, but that doesn't going to affect the land bank because she wasn't within the chain of title. It was fraudulent. So it doesn't make any difference that there's no standing here, sir.
Okay, so I just want to make sure, because I don't when it comes to, I'm looking at the statute, when it comes to notice and all that stuff, I don't have copies of any of the notices that were sent to my client. So I'm just wondering, is the court gonna allow a contested hearing or
no, because he doesn't have standing.
Okay.
Basically.
And
Mr. Thomas.
If I may share, so I believe what he's saying is his client didn't get served. I have a green card with his client's signature. I also have a proof of service with occupant mailing. I have a proof of service with posting. I have a proof of service. I have all the proofs of service.
I haven't seen any of those. So I'm just, I have to put that on the record.
You need to check the docket, but here, I'll show you your client's signature.
No, Mr. No, you can send it to email it to him. We've had a long day. You can email it to him.
Fair enough, Your Honor.
So Mr. Thomas will email it to you, but still the court, posted it. I'm sorry, not the court. The land bank posted as it properly should have, and he'll get you the information. But the long and short of it, that your client doesn't have standing because it's part of a fraudulent conveyance. So we're going to go ahead and enter default judgment, but he'll get you that information. Correct, Mr. Thomas?
I will do that, Your Honor.
Okay.
Okay, and then I think if that's where the court's going, that's would also apply to Gartner. Andrew, is that correct?
I don't know, Mr. Thomas, what are we talking about?
That's what we were talking about, Gardner.
Yeah.
We were talking about the Gartner, or because that.
Yes, we were talking about Gardner.
Okay.
On the Lawndale cases, your client conveyed the property to himself. Would you like to see those deeds, sir?
Yeah, I haven't seen those.
Okay, Mr. Thomas, email those to Mr. Khan.
All right. And this was another case where, again, the property was foreclosed on. In 2017, that notice of foreclosure was properly recorded. It was then conveyed to the Detroit Land Bank. That deed was properly recorded. And then Eric Fernandez Herrera in 2025 conveyed the property to himself And that's on both the Lawndale properties.
Okay, and so the court's gonna go ahead and enter the default judgment quieting title, but Mr. Thomas is going to, you have his email address, Mr.
I
Thomas?
do. He's emailed
Okay.
me quite a bit.
Okay, so you're gonna provide him with that information.
I would, yes.
Okay, so and you
And
can
that'll
use
be
that.
tomorrow morning, sir.
Yeah, and you can use that in your other case. Okay, thank you.
Thank you, Your Honor.
I guess Ms. Anderson says she's done. Who has the last case?
There's all still mine.
Okay, Ms. Clifton, did you put Mr. Ahmed, he's still in there. Did you send him a text? I mean a chat in the chat that his case has been adjourned?
I did.
Okay, all right, we'll leave him alone. We'll
Okay.
bring it, you can bring in Mr. Jones and we'll see what's
Okay.
going on with Mr. Jones. Whew, long day. Long day. And
You're
you see
doing
I-
amazing, Judge. You're
Oh
hanging
my
in there
God.
through some.
I know, and I said I had to take a few minutes to get me something to eat, and a personal minute break. I was like, whew, Lord, long day. And from meetings to motions and to hearings and whew. Okay, Mr. Jones, you want to turn on your camera and we'll call the case? No, Mr. Jones. Last but not least, come on, Mr. Jones. Mr. Jones probably went someplace. He said, you are taking too long for me.
He had logged in with an iPhone. And so there were two. I don't see
The
it.
iPhone's gone.
Oh.
Well, we can put Mr. Jones over. Which case was he, Mr. Thomas?
And that's what he's asking for. The situation with him, he's Euclid, West Euclid, 1724 West Euclid. I was hoping for the intelligence of the whole group to help him out. Somebody in his family owned a combined lot. They didn't pay taxes on the vacant lot that was attached to the thing. They lost it well over a decade ago. He wants to purchase that property as a side lot. My understanding is we have, in order to sell it to him as a side lot, we got to finish this
So you're
this
in
quiet
essence,
title.
okay, so can we?
So it's how do we help him the most, I guess.
So can we? Mr. Jones.
Yes.
Do we need to put this over? Because I know
We should.
Okay.
That's what he wanted anyway.
Okay, all right, go ahead, put it over to, what we're gonna do, the 18th? Is it the 18th?
You
March?
want to give him till February 18th?
Is that Miss Clifton, we're using February 18th?
Yeah, Zoom.
Okay, so Mr. Thomas, can you send him an email and tell him February 18th at 3 o'clock?
I will. He's a real nice guy.
Okay, we'll try to get him in early and well, you're gonna have a conversation with him anyway to make sure.
I'm going to have a conversation with him. I don't think he's your typical contester. I think he just is looking to get things done the right way.
Okay, all right. So we'll put him over to February the 18th at 3. Oh, here come, I bet you that's Mr. Jones on this iPhone.
Hold on.
You think so?
Yes.
Mr. Jones, is this you on the iPhone?
It is, Your Honor.
Okay, so we had a conversation without you because we saw that other piece of you on some other device. But anyway, what Mr. Thomas is going to communicate with you, and we're going to put this over to February the 18th because he'll explain everything, but he's basically indicated that you want to do it the right way. Your family, I think, wants to purchase that side lot. So Mr. Thomas will communicate with you how we need to proceed so that we can ensure that happens for you.
Thank you.
Okay, so but we'll put it over to February the.
And just to be clear, I'm making no promises that he's going to be eligible or any of those kind of things. But we'll give you the time you want to do your look at the
Your due
title.
diligence.
I understand that you can't make any promises. Again, my grandmother died 10 years ago, and she had dementia, but
Okay.
I appreciate the time.
Okay, but like I said, Mr. Thomas will be in touch with you. We'll put it over to the 18th, and hopefully, we're going to put this in the best position for you to possibly retain
Understood.
the
Thank
Okay.
you.
Okay, thank you. We'll see you
All right.
then.
Pleasure, Mr. Jones.
Thank you.
Okay, take care.
Bye-bye.
You too. Bye now. Okay, everyone, thank you for
Your Honor, I'm sorry. I think do we have 4 properties that are still up for 12, but no one is here?
Correct. For the default.
Okay, 4 on 12. So Ms. Clifton, you already called it, right?
Yes.
Okay, so which ones are left, Ms. Jemison?
Parcel 2, 3, 6, and 8.
2,
Correct.
6, and 8. Okay, so as to 2, 3, 6, and 8, what's your pleasure?
Good afternoon, good evening,
Yeah,
Your Honor.
evening.
My name is Andrew Thomas. I'm an attorney for the Detroit Land Bank. Today is the time and date set for Land Bank's petition for judgment of quiet title under Quiet Title Fast Track Act. The Land Bank followed the Act's notice requirements, compliance with the Act's notice requirements until the Detroit Land Bank Authority to quiet title judgment. As such, the Detroit Land Bank Authority requests quiet title judgment for 10249 Goodwin, 8538 Green Lawn, 2440 Parker, and 9934 Ward.
Okay, based on the representation placed on the record, the court is satisfied the court will enter default judgment quieting title as it relates to those 3 respective properties, correct? It was
4,
2, 3, 2, 3, what?
7, 2, 3, 6, and 8.
Okay, 2, which is 10249 Goodwin. 1818, no. 2440
2, 3,
Parker. Okay,
2, 3, which was 8538 Green Lawn,
and then the 2440 Parker and the 9934 Ward.
9934 Ward.
Yeah, the court will enter default judgment quieting title. Whew. Whew.
Well, we earned our salaries today.
Yes, and then some.
Thank you, Your Honor, for your patience. Thank you so
No
much.
problem. And then Kimberly's gonna give me her overtime slip.
Yep, it's on the way.
When we stop the record.
Wrong, Kim.
Okay, hold on. Let me stop. I was talking about